Welcome to Looking at Legal Stuff. Today we have 15 hearings in a very high conflict divorce where Dad has filed for divorce after a DV incident that led to criminal charges against him. Mom doesn't want Dad to be able to have any contact with her or their two youngest sons, who she says are too traumatized by the incident and do not want to see him. She drags her feet about taking them to scheduled supervised video calls with a therapist. Mom also continues to refuse to participate in the discovery process, claiming that Dad's requests for discovery are just new control and abuse tactics, and she says she wants the judge to restrict Dad from abuse litigation. It isn't just Mom who wants to keep Dad from the children. The GAL tells the court that she regrets her recommendation that gave Dad supervised video calls, and she says she made her final report before she received additional information that showed her how dangerous a man Dad actually is. Will the judge be convinced to keep Dad from seeing his children? Let's find out.
Ramos and Ramos Curio matter, which is 24-39408.
We do not have an agreed plan on how to go forward. My argument is this. This was heard 3 weeks ago with Judge Warning, with essentially the exact same evidence. The difference between today and Judge Warning is essentially, even per the mother's declaration, is that at the first exchange of the 4-year-old, the 4-year-old had a meltdown and cried. That is the big change. That is not the basis of an ex parte restraining order. Judge Warning heard this, had the same brick or nearly the same brick of information, but the only change, the only new thing that has happened is that the 4-year-old doing an exchange at night in front of a police station with officers present, mother doing the exchange. So we have not a neutral party doing the exchange, so not ideal. We have a 4-year-old, a preschooler, having a meltdown. Not too shocking. My client wants to have visitation. He does not want this to just simply be kicked down the road and not having visitation. Mother agrees that visitation happened for the older 2 children. There's 4 children at issue. The older 2 children continued to have visitation with my client this last weekend. The court ordered every weekend to my client from Friday to Monday morning drop off. So the other 2 children with my client with no issue. The 4-year-old cried, so we got an ex parte restraining order Friday at, essentially my client responded without ever having seen the motion. So we just were told it was coming over and we made a good faith effort to put a declaration together. But here we are. So my client doesn't believe this is valid. It's not reasonable. This is not how we do business. They were aware on Friday that this incident happened. We're going to then waiting until the following Friday at essentially 1 o'clock to then provide the motion. This isn't reasonable. The court then reasonably gets a brick of paper, not knowing it's the same brick Judge Warning got, and then says, oh, well, this, I see a brick of paper, must be substantial. I'll sign the ex parte restraining order, making it so that my client doesn't have access to the 2 youngest children. My client thinks it's imperative that he have visits with these children. The guardian ad litem is doing an investigation. Hard to say what those children are like in my client's home if he doesn't have them in his home. And there's really no statement that the 2-year-old has any issues at all. So as to my client, he does not want to just kick the can down the road and say, oh, well, we'll just kick it and go additional weeks. Judge Warning made this order essentially the first week of March. We went multiple weeks without the order being executed. So essentially, Mom then delayed the visitation. We had modifications made in the DVPO order. We had modifications made in the criminal case. So all of that was aligned. The very first weekend this exchange was to happen. Now we have this reason and a very late breaking restraining order that doesn't make a lot of sense. I'll note for the court, mother's very first exhibit that she attaches to her declaration is, oh, look, by the way, he's got an old 2008 felony. She provides that judgment and sentence, but doesn't provide that it was vacated 2 years later. So these are the types of pieces of evidence, I think, that are very misleading, is when you say, oh, there's a big judgment and sentence. It's almost 20 years old and it's been vacated. So again, in this case, I'm asking the court to allow visitation to continue as it was intended. After that, I don't disagree then setting it out, allowing my client to have the visits that the court intended, and to allow the guardian ad litem to investigate as intended with all of the children in both homes, so that it can be investigated in both homes.
And Your Honor, if I may,
Let me ask a question. The, the order that we're working under prior to the current restraining order, that's the order that was entered 3/15. Looks like Judge Evans signed it, but I believe that was Judge Warning's order. Is that correct?
Yes, that's
Okay,
correct.
I just want to make sure
It's
I'm
a
looking at the right.
temporary order, and then it's not a parenting plan, it's a temporary order that
Right.
has the
Okay.
details. Yes.
Okay, I just want to make sure I'm looking at the right piece of paper. All right, Ms. Winkles, go ahead.
yes, Your Honor, not exactly a complete resuscitation of the facts. First, Judge Warning stated that there was so much evidence he couldn't figure out who was telling the truth and who wasn't. Second, he also stated in open court that he hadn't had the chance to read everything, considering how much information was presented. We now have a third party who has no dog in this fight, and that's the GAL, who's here today to give more information. Additionally, this 4-year-old was the one that, when Mr. Ramos was arrested for strangling my client on assault 2 DV, he was also arrested for reckless endangerment to children. And the reason he was arrested for that is the 4-year-old was in his arms as he was standing, or sorry, sitting on top of mother and strangling her. Mother had the 4-year-old. The 4-year-old sees all this. The fact is that the visitation transfer was supposed to take place at the police station at LPD. LPD is the one who did not allow these children to go with dad because the 4-year-old threw such a fit. We're not talking about crying. We're talking about a 4-year-old in a complete traumatic breakdown. The fact is that I would have loved to have done this that day. I have pneumonia. I was sick. My apologies for getting it late to the court. I did give Ms. Baldwin the opportunity to respond. I did send it to her at 12:30. Her response came over to us at 1:30. We took everything to the court. At that point, it took the court 4 hours, I believe, to read. I'm not sure if the GAL put anything in. We also notified the GAL. The fact is that it would be a devastating blow to a 4-year-old that's already seen father strangling mother. And we had photos of abuse at the time. We had a video that the GALs reviewed. And at the time of the first court case, we didn't have this, where dad is berating the children and cursing at them. We have the GAL having now reviewed dad snorting cocaine as he's driving. Again, at the first hearing, this was not, there was no third party verification. We had a snapshot of dad holding a bag of cocaine in his hand. We have evidence of bruising, medical records showing bruising. We have independent third parties. Mr. Ramos was trespassed from Fiber Federal. My client declares that he was trespassed because he was making death threats to people who were getting in the middle of their altercation that was going on. My client, at the time of the first hearing, there was none of this independent third-party verification there is now. Additionally, we supplied other police reports. This man does not just have a 20-year-old assault for DV. This man has been arrested for domestic violence on 3 separate occasions and convicted on them all. They were vacated at some later point in time in his attempt to get through Homeland Security. He's also currently in the process of being deported from this country due to that. There's also allegations, which we had no idea about in those police reports, about child abuse, which is completely a different topic. I won't go into more detail about that. The police reports are with your honor. The fact is that it appears that dad's on his best behavior with the older kids, but this younger child needs to have some sort of safety measure in place, reunification. The fact is, to have this child view his dad's his mother, and then to suddenly give child to dad would be a complete, essentially complete letdown of any safety measure, that the reason why we're here in court. The other thing is the DVPO has not been modified. We haven't had a hearing. What we did is allow everything to rest on this case. We agreed, we didn't have to modify the DVPO to meet this family law order, considering the amount of investigation the GAO would make in this case and not in the other case. We have photos of dad giving alcohol to his older kids that are still minors. We have so much evidence in this case, so much weight. My client also took a lie detector test, and your honor can give that weight to however much you want. But the fact is that we have so much corroborating evidence to show that dad has beaten women in the past, the present, has been absolutely vile to his own children. The fact is the older kids are so desensitized to this abuse, likely their trauma has already occurred. How we can go about fixing that, we need to think about for the future. But this 4-year-old is still somewhat of a blank slate, and the 2-year-old is still in diapers and it is not nonverbal, but less than verbal. The 4-year-old has an amazing retention of vocabulary and has the amazing ability to say what he wants. Miss Call is here today. I'd ask that if I'd ask for a set over, clearly, Your Honor can hear my voice. I just got back from the doctor. I'd ask for a set over for myself so that I can give a reasoned response. But in the interim, the fact is, Dad created this situation. Dad can wait another week. Miss Call is here today. I'd ask that the court talk to her because that's what Judge Morning was missing. He clearly stated these orders are very temporary until the GAL has a chance to do somewhat of an investigation. He gave her a very small fee just to get it started. That's how we know that this was all hinging on the GAL. He said, Miss Call, how much do you need to get started? And that's why we haven't even paid the full amount because it hasn't been entered. She's here today, Your Honor. I'd ask that she be allowed to speak to the court and say what she's found so far. She's had a couple of weeks to do an investigation. I think she's probably in the best place rather than a he said, she said, although she said with a million documents behind her.
Ms. Call, can you shed any light? You are muted at the moment. Can you shed any light on where we're at today?
Yes, thank you, Your Honor. At this point in time, I've had the opportunity to meet with both parents. I've spent time with the two younger children at home with their mother, and I have spent time at school outside of either parents with the two older children. I also yesterday received a pretty troubling phone call from the oldest daughter from school because she had been instructed to call me and tell me about some things that her father was sharing with her over the weekend. I'm very concerned that these older children are being coached and coerced potentially by both parties, but right now I'm being told that Mr. Ramos has asked the oldest daughter to share some things with me. At this point in time, the recommendations that I'm prepared to make is that the visitation remain as it's currently set up, which is the two youngest children stay with their mother, in part because both of them looked at me while I sat at their dining room table and said, I do not want to see Poppy. And they were visibly scared, expressing very clearly to me without any issue that they're scared to see their father right now and don't want to. Solomon, the 4-year-old, is very clear with me about that. Obviously, the 2-year-old, that's a tougher call to make. But Solomon, the 4-year-old, is very expressive, very verbal, very clear. The two older children are very happy to spend time with their father. They miss him and want more time with him. However, I am concerned that Mr. Ramos is sharing details of this case with the children that should not be shared. Selena, the oldest daughter, has information regarding details around how much child support is being paid, cash that Mr. Ramos keeps in the vehicle that mom is now driving. She had lots of opinions and thoughts on what should happen in this case. I was very troubled by the information that was being shared with me. My further recommendations at this point is that father submit to the hair follicle test that he's been ordered to take that he has not submitted to yet. We have a lot of allegations surrounding substance abuse that has not been addressed. Mother did submit. We have her test results. Further, I'd ask that each parent be asked to submit to a psychological evaluation by a PhD level licensed professional. And further, that father have a domestic violence assessment and attend treatment as recommended by a PhD level professional. I think that there's going to be some information in those evaluations that are deeply important. I've submitted those recommendations to both attorneys. To be honest with Your Honor, those recommendations just came to them recent moments before we had court, in part because I wasn't sure we'd actually get to speak today. I was concerned we'd end up in a set over. So I wanted them to have information about what I was going to recommend going forward in the hopes that we could agree between parties that these evaluations take place. I have very real concerns on both sides of this case. At this time, my interest is in making sure that those younger children stay with their mother where they very clearly feel most safe and protected. And that's where I'm at this point in time, Your Honor.
Okay. Ms. Baldwin, you had started off our discussion. Would you like to respond?
Yes, thank you. So with older children, when they come to a parent and say, hey, X and Y are happening, the response is tell the guardian ad litem. So that isn't an unusual thing. Yeah, you should tell the guardian ad litem anything you want to tell them. That's the correct thing to tell children of an older age. When we talk about the 2 and the 4-year-old, everyone essentially acknowledges 2-year-old doesn't have any issues. The 4-year-old, it's 4-year-old is afraid, sitting at the dining room table of the mother in the mother's home, arguably, if not directly in the mother's presence, knowing that the mother is home. That child, 4-year-olds are not stupid in the sense that that child's not going to bite the hand that feeds it. That child is fully aware of they don't have the option of going against mom. They have no ability to self-subsist. And this is the only parent that is available to them because father's been eliminated. And that was Judge Warning's concern. Is we've eliminated father and the resource that father is and the safety net that father is. So we now have a 4-year-old who has to say or has to do because child doesn't have any options. So again, a lot of concerns, and especially at that age. Everybody here is saying, oh, how articulate 4-year-old is, what vocabulary is it? Or is this a 4-year-old who's been coached to use those words and to say those things because that supports mother's story? And because older children maybe don't support mother's full story, but a 4-year-old is a really easy target to manipulate. And we know that. That's why children who are 4 rarely pass Ryan hearings, because they really don't know the difference between a truth and a lie, really don't know the difference, and are very easy to manipulate. So these are why the concern is increasing, is that mother prevented access over essentially the whole month of March to that child by my client. And now essentially when that access is going to happen, now we've continued that. My client's happy to have some kind of alternative, but again, it's sort of a all or nothing situation that's being offered here. I don't think that that's reasonable. When it comes to there's all of this evidence, but most of it really doesn't hold a lot of water. Again, when it's like, oh, well, this conviction that was vacated, well, these police reports that went nowhere. Just because somebody has a police report doesn't mean that they were found guilty, doesn't mean that that evidence held any water. My client is a brown-skinned person in a pretty white county. He gets contacted more by law enforcement than other people. He recognizes that. It doesn't mean that he has more criminal behavior than other people. So again, concerns. Both of these parties have substantial evidence. There's videos on both sides. There's witnesses on both sides. There's photos on both sides. So again, that's one of the reasons why Judge Warning was like, I have a lot of concern on both sides. It isn't just hey, they have a brick of evidence and I haven't looked at it. It was, there's a lot of evidence on both sides and I have a lot of concern. So in this case, if we'd ask that the court not maintain this order, at a minimum, the 2 oldest should, and nobody's disputing, the 2 oldest should continue to go with my client. The 2-year-old should go with my client. No one's saying there's any issue with that child. Why would we prevent the visit when there's literally no issue with that child at all? The 4-year-old, at the bare minimum, there should be some type of visit that's allowed that's with an exchange that does not involve the mother at all. That can be professionally supervised. That can be some kind of soft visit that happens in a park where there's some neutral third party there. Again, my client just doesn't want to be in a position where we further and further and further entrench this sort of fear that's been created. That is my client's concern, and it's a valid one, that we just go longer and longer and it makes things in the end harder for that child. As to the evaluations, in the long run, my client would say what's good for the goose is good for the gander, but there's a very clear reality as to cost for all of these folks. Mental health evaluations with PhD level providers, that's lovely. Those are multi-$1,000 evaluations. Domestic violence evaluations, both of these parties allege domestic violence against each other and against the children. Well, actually, my client alleges that Mrs. has directly struck the children. She does not allege that, to my knowledge, regarding my client. It would be valid to ask for those. To my knowledge, those people are not PhDs. Miss Olivia Lovely is the local person that does them. I don't believe she's a PhD. So, and I'm not sure that they're done by PhDs. Whatever the court does, orders as far as evaluations, they should just be, frankly, as to both, because the concerns are frankly as to both. But I have real concerns about the dollars involved as to both of these folks. My client was initially ordered to pay many thousands of dollars. He has struggled to do that. He has put paying his obligations to mother towards the mortgage that was court ordered to maintain the family, or not mortgage, to the rent for mother, to support for her, to daycare for the child, to paying all of those things. Those have been the priority for him. And making sure all of those things got done. So he put those first, and he recognizes those had to be sort of put first before he paid for anything else.
Right.
Any response from me, Your Honor?
I'm sorry?
Can I do a brief response?
Brief response, go ahead.
The fact is that Dad has almost an unlimited supply of cash. As we've stated, Dad has a side job of selling drugs. Again, videos were provided to Miss Gall. Mom found the way to pay me through cash, just tens of thousands of dollars just sitting in a car. Just one of the vehicles that were paid in cash. This man has Mercedes, Jaguars, BMWs, all very new models, all paid in cash. Dad has enough money to get these evaluations. Mom has never been tried and convicted by a jury of his peers or of her peers for assault. Dad has. Whether or not Dad got those vacated, it doesn't matter. Dad was convicted of them on appeal. He lost. He did appeal one. He lost. His conviction stood until he vacated them years later. The fact is, Dad also came to this court back in 2015 claiming he was sober. We submitted that declaration, yet Dad had a DUI he failed to disclose to the court only months before. The veracity and credibility of Dad is very, very little. The credibility of Mom has never been impugned, except for by Dad and some third-party declarant neighbor that claimed he saw Mom outside screaming and muttering to herself. That's about the extent of it. Dad's entire argument is that Mom is crazy. We have videos that show pretty much everything that we've stated. We provided screenshots. We have police report after police report after police report going all the way back to 2011. We have police reports from other matters involving other women. We have everything that anyone could ever ask for, including including medical records that day, and where mother didn't even press charges, stating in 2011, 2012, 2014, Dad beat me up, Dad did this, yet she stays with the man. If she has a mental health issue, it's the fact that she stayed with an abuser. There's nothing else that Dad has supplied. And Dad wanted this hair follicle so badly. He paid for Mom's, yet he doesn't take one. Mom does, and Mom passes. Mom's clean. Dad doesn't take one, waits long enough to where, oh, lo and behold, now we're clean. It's a bit shocking that Dad was able to get any visitation to start with. However, it appears the older children, again, desensitized, want visitation with Dad. The younger children, both of them, not just one of them, both of them have indicated they do not feel safe with Dad. The fact is, Dad created this. This is not Mom coaching. This is Dad sitting on top of Mom, her with a closed fist and then strangling her while he sat on top of her while the child was in her arms. The police come. He claims it was all Mom hitting herself. You can read the police report. And they say there's no way those marks were made. And that is a signed declaration under penalty of perjury. There is no way that Mom could have strangled herself with her hands and show the marks that she did. You can see the bruise, massive bruise on the side of her face where she was over and over again. You can see the bruises all over her body. You can see them go from January, April, back, just bruises covering herself. The fact is that these children are actually in a very unsafe situation with Dad. The fact is that Dad is probably most likely on his best behavior, which is the only reason I'm not arguing today for no visitation until Dad has treatment. Dad was ordered back in 2015 to undergo batterer's treatment. He failed to do it. He keeps getting away with this, and somebody keeps getting more and more injured. All it takes is one little slap to a 2-year-old, and that's the end of the story. And Dad's not here legally. So the recourses of this court are very limited in that case. These kids need to be protected. 1 week, 2 weeks is not going to ruin Dad, is not going to turn the tides and make suddenly these kids hate a man that they loved 2 weeks before. But what it can do is protect these children for the next 14 days until the guardian ad litem can do more. And it can protect them until more is done, until psychological evaluation is done. This court does not want to hand these kids over to dad, who has already threatened to flee to Mexico. They don't want to hand these kids over where something bad might happen when the dad only had to wait 14 days. This isn't about the best interests of dad. This isn't about dad. This is about the best interests of the children. And that is to be protected until somebody can figure out what's going on. Olivia Lovely was the person in charge of the last hearing back in 2015, where dad, I guess dad did go through a week of treatment or something like that. We'd ask that it be somebody else this time. There are other providers, somebody brand new, where mom has a chance and there's no other females that were already there. So that's what we're asking for. PhD seems appropriate. Dr. Maharg is one of those providers that is there available. I believe mom has already engaged Dr. Maharg for that very purpose. Dad can too. I don't think that's an issue, but at least the court will have somebody, Dr. Maharg's opinion of what really is going on here. I think that's vital to this before we hand over a 2-year-old and a 4-year-old that really can't protect themselves.
I'll just make clear that the immigration arguments are not proper. That they're nowhere in the law does status allowed to be part of the decision.
Thank you. All right. I was going to raise that comment myself. Immigration status on any court hearing in Washington State is really inappropriate. So please do not, I don't want to hear that anymore in this courtroom. That's not an issue the court's going to consider, whether it's true or not. It's just not appropriate. So I guess what I'm concerned about, I've had the probably more opportunity to review the documents in this case, not as many the most current, because I did a protection order hearing. So I reviewed this case a number of times. So, and I could say after review of a lot of information, it's not 100% clear to me what all's happening and what all are the facts. I know there are certainly some concerning behaviors concerning to the court. What I think is swaying me today, in the reason, well, first I'll tell you what I'm going to do. I'll tell you why. I am going to pull the 2 younger kids out of the visits on a temporary basis. I don't. First off, I don't know that we can have the evaluations that are being suggested in 2 weeks, and I guess I'd like to see a more detailed report as to the basis of that. I'm not sure that having a psychological evaluation is going to have all that much impact on what court has to do, frankly. They may be useful for certain things, but depending on who does it, what it's for, what the parameters are, it may or may not help the court. But my concern really, and I look at the fact that I have, and again, this is an allegation purely, but I have an information specifically that lists the 4-year-old as being part of a criminal case. And I understand this is an unusual case where there were some, I think it was Judge Evans heard that hearing, but there was at least some indication that, go ahead and change the protection order in the criminal case. It's highly unusual in the middle of a case of that significance, but I'm not second guessing those decisions. But I am going to pull the 2 younger kids out, and at least at this point, certainly can reconsider that once Ms. Calls had a more time to dig into this a bit more. I think that both counsel, you need to talk to your clients. These kids do not need to be involved in discussions about this case at all. They don't need to know what's going on, because whatever trauma may have already happened, this is simply redoes that, and that's just not appropriate for kids. So the order that was entered on the was it the 11th or the 15th? I think it's the 15th. Get the right page here.
The 15th.
15th. That'll remain in full force in effect, except that the 2 younger kids, Solomon and Benjamin, I'm going to pull out of that order, and they'll be. I don't have any huge issue if they want to have maybe once a week a video chat or something, but I think at this point I'm going to pull them out. So are there other issues that need to be argued at this point, or are we just, you want to set the rest of the issues out?
No.
If we can set the rest of the issues out, that'd be great for me, but I'll, Ms. Baldwin may have a different take.
No, the rest of the issues, so the order, so when, I'm sorry, I just want to clarify, when you're saying in a pool, the younger two, but potentially do some sort of video visit, is that the court's intention with the two
Yeah.
younger children?
Yeah, if they want to have like a weekly video chat with the younger ones, and again, I know a 4-year-old and 2-year-old. If they don't want to do it, they don't have to do it. But I think that give them that opportunity at least.
Can we ask that that be professionally supervised? My concern is that if it's with mother in mother's house, it'll just never happen, that the children really won't be given that opportunity. So we'd like that to be at either utilizing essentially a visit coordinator or a professional supervision agency so the children can actually have the opportunity to have that happen.
I don't want it to happen.
And my question would be, who would pay for that? How would we set that up? How long would it take? If Miss Call, I know she needs to see dad with the kids. Maybe that's something Miss Call can do because we're only talking about a 2-week set over. Maybe we do it once with Miss Call present. That might be a way that we could see dad with the 2 kids as well.
Ms. Call, do you see that as helpful to your investigation?
I believe so. Yes, I will tell Your Honor, I'm not sure that Solomon will participate in a conversation with his dad, but if we're able to make that happen, I'm happy to be present and a part of that.
And I'm not ordering Solomon to participate. I'm just the opportunity to be there, obviously. So I think I guess if parties can coordinate with Ms. Call to do that, I think that actually is a really good idea. That's probably very helpful.
And I just ask that it not be at mother's home. If it's at mother's home, I think then children feel pressure to not
I think that's probably a good thing. I don't know, do you have an office that they can go to, or would there be
They can also go to my office. We can stick them
Anywhere
in
is
a
fine.
conference room.
yeah, just someplace else, that's fine. Okay,
Okay.
any other issues? I guess what I'd like to do then, do you want to go at 2 weeks on this or 1?
Yeah. 2 weeks would be great for me, Your Honor.
So
That takes us week
Instead of-
after.
Your Honor, sorry to be crass, but can we address the remainder of my fee as well so I can continue investigating? I've almost hit
That's right.
the amount of time.
Ms. Call was, so the original order for Ms. Call was only like $1,000, I think. It is reasonable that the remainder of her fee be paid. My client was ordered to pay, I think, the entirety of that initial $1,000. I would just ask that the remaining portion be 50-50 between the parties. According to Ms. Winkles, her client received tens of thousands of dollars from the community vehicle. So it's reasonable that they split Ms. Call's remaining fee.
My clients paid attorney fees with the money that she found. Those attorney fees, given the amount of times we've been here, have ended 3 hearings. Or sorry, 3 different matters have already been spent. My client has 0 job. She's on TANF. So it would be appropriate for her share to be county pay, given that she's on TANF and food stamps.
what was the original order? I mean, the order, I know that Judge Warning ordered $1,000 be paid immediately to get things going. That wasn't the order as to her fee.
So there is an order appointing guardian ad litem. And
Right,
so
I
there's
see that.
2.
Okay.
Yeah, there's an amended one. Look
Okay.
at the amended.
I just have the one from 315.
Yes, 315,
Mhm.
and it's on page.
Yeah, it says 3,300 max.
Yes,
1,000
but
legally with 2,000 remaining.
yes, and you're to decide who pays the 2,000 today.
Okay.
And to be clear, Your Honor, he actually paid me 1,100, just to be clear about that.
Okay.
And again, my client's on TANF and food stamps, and any money she found in the car has gone to my fee.
All right. Well, I guess, and not having done the math on these before, if you're part at county and part at private, does that change the fee, or how does that?
I've had this happen in the past. What I do is just calculate whatever that cap number is and
Mhm.
divide it down the middle. I mean, if, because the county fee is considerably less than a private pay fee, I just try to do the best math I can These cases tend to use quite a number more hours than are allotted. But I try to do the best I can to be ethical and have those numbers match.
So let me do this. I think what I'm gonna do, I'm gonna put mom's at county pay. I'm gonna leave his at private pay. So split that number up according to your normal formula. I'm also recognizing this is a case where I'll see some requests for additional fees, and those will certainly be appropriate, I think, in this case.
Thank
So
you.
is
Your Honor.
so your intention is to 50-50 the remaining mom's county pay, and then we'll figure out the math for Mr.'s.
Yeah.
Okay.
Yeah.
All right, very good.
I don't do math in public on the docket.
It's fair. I don't either.
I try not to either, Your Honor.
So, but obviously your fees is what it's supposed to be, so. Okay, and again, if you do need additional fees, I expect this is a case that'll probably be a bit more work than a typical one, so I wouldn't be surprised. Okay,
I expect that's true. Thank you, Your Honor.
all right,
Great,
so
thank
put
you.
the balance this over 1 or 2 weeks, excuse me, over the 9th of April. And what I would ask counsel, I don't need a whole lot more filings, but if either of you could submit me like a 1-page document as to the specific remaining issues you want me to look at. So when I come back and review this for 2 weeks from now, I will be able to isolate what the focus is.
And respectfully, I'd like to respond. They didn't provide me this motion until 1 o'clock. Literally, we wrote the response
But
blind.
you can certainly, if you want to respond more, I'm fine with that.
Yeah.
But if I don't need it, I just want to focus in on what it is out of this gigantic file that I have, what I need to focus on. That'd be helpful.
Okay,
Very good.
Okay.
great. Thank you, Your Honor.
And I can, if you can't agree on an order, we can put it on for next week for presentation if you want.
I'm hopeful we can be fine.
Okay.
I think we can come up with something. Thank you.
Very good. All right.
Agreed set overs, Your Honor.
Very good.
So number 11 and 12, Ramos and Ramos. I have Ms. Winkles as well as our guardian ad litem. We're agreed to set that matter over 1 week. Parties are just working to see if we can iron some things out without your intervention.
Okay, and everybody's in agreement with that?
Yes.
Okay. That was, I'm glad you're saying that because my notes indicated you were all going to send me some sort of a list of what was left to be decided, and I did not locate that anywhere in all of the other voluminous documents that showed up. So
Correct.
we'll set it over a week. And again, if you could do that prior to that hearing, that'd be really helpful. So over to the 16th at 1 o'clock.
Yes, very good.
Thank you, Your Honor.
Okay, and tell Ramos also over to May 7th.
That's correct. And Ms. Winkles, we chatted this afternoon. She had a personal matter, so she apologizes, but we
Very
both agreed.
good, thank you. Ramos and Ramos Curial Matters, I do have, looks like agreed. Orders, I believe, Mr. Baldwin, have you seen these?
Ms. Baldwin told me that orders have been going back and forth. I think there may have been a recent, I don't know how recent change, so I don't know if Your Honor has in front of you. The parties intended that there would be orders entered today. So I'm assuming yes, Your Honor.
Well, I
Ms.
know
Winkles
they've been signed up by Ms. Winkles, I don't.
I'm here for Ms. Baldwin because she had indicated that the parties had reached an agreement on the temporary orders and setting the matter over to the 21st. I think extending the restraint, but I'll defer to Ms. Winkles here initially.
Ms. Winkles?
Yes, I did get an email about an hour ago from Miss Baldwin that asked for the Word version, so I'm not sure which one she wanted to change. It
Okay.
appears though that one she did want to make a change on. I'm assuming it's not the Shirley matter because I would assume that that would not be the one that she wants to change. The other one did have some caveats in there that she might have wanted to include on that. So I would assume that the Shirley one's okay. However, we can shoot Your Honor an email and let you know of that and get it to you before the end of the day.
And that'd be my request. If Your Honor could hold off signing anything right now, and Ms. Baldwin, if they're going back and forth, should have them signed to Ms. Winkles and everything should be fine. I think over to the 21st, is that right?
That's correct. And just so Your
Yep.
Honor's aware, for the record, the GAL is attending today, and that might be my fault for not getting her information soon enough.
Okay, just a second here, that would be Ms. Kale?
I'm not
That's correct.
concerned about being here. I'm here anyway today.
Okay, All right, so this will be over to the 21st. Now, that much I knew. I don't know about the details, but so we're over to the 21st at 1 o'clock.
Thank you,
All
Judge.
right. Thank you, Your Honor.
Thank you.
Yes, Your Honor, numbers 1 and 2, Ramos and Ramos.
Yeah, we left this on for review. I know there's some other matters pending that are over on to next week.
Yes, Your Honor, we're just gonna continue it actually and continue the ones next week as well till the 28th when Miss Baldwin's available. We're doing just gonna extend them. We're doing a little bit of a carve out in the Shirley, Ramos v. Shirley, to allow the boys to go visit their father this weekend because they are almost 18. We are super close. On the other one, I think the GAL's present here. We're gonna do a carve out to allow reunification therapy with Charlotte Rosen to begin. I'm not sure. I don't see the GAL, but my screen is completely full. So hopefully she is here.
And I think Ms. Baldwin and Ms. Winkles have been back and forth to finish up that language to present an order for the court today. I think we just asked that everything be over to the 28th. They'll provide the order for signature, and the parties are working towards trying to come up with a resolution on all matters. Hence the
So both
regular
matters,
appearances.
which would be 20-093-72208 and 24-39408 over to the 28th.
Yes, Your Honor.
I believe there are some matters that are on for next week, and you're asking to strike the hearing next week or set that over to the 28th as well.
Set them over as well.
Okay, so everything there'll be no more hearings till the 28th. And then if you send over an order, we'll be happy to sign it.
All right.
Perfect.
Thank you, Your Honor.
Thank you, Judge. 7 and 8, Ramos and Ramos and Ramos and Ramos. Those matters are over 1 week. Is that correct, Ms. Winkles?
That's correct. Ramos v. Ramos 24-3-00094-08 and Ramos v. Shirley 09-3-00722-0. Both of them over 1 week. Still
Very
trying to
good.
get a settlement.
Very good, thank you. Ramos Curio matters, there's 2 cases, 3093-72208 and 24-39408. Council, did you all have a chance to talk after yesterday? We're looking at maybe setting this over to the 18th or?
The 18th is fine. I think Your Honor noted sort of a concern about sort of hearing the protection order side as well as the contempts and the family law side, and sort of the problems with the evidentiary issues that obviously are different depending on the type of hearing. I tend to agree. I don't think that Your Honor is incapable of making those distinctions. But I think what might be smart is to do the DVPO side on that date that you've referenced, and then set the contempts to a different day, maybe 2 or 3 weeks later, so that there's sort of a time separation between those. My thought is sort of the time separation then allows those things to sort of rest, and then the contempts to sort of been taken on their own merit, and then sort of the evidence is what it is, instead of sort of it all being sort of a fire at the same time.
Yeah, I did have a chance to think about it, and my concern, there was at least some discussion. I know there was a number of emails back and forth about potentially consolidating all 4 cases. That was really my concern because there's obviously different evidentiary standards between the protection orders and the domestic cases. So as long as we don't do the domestic and the protection orders on the same day, that'll be workable. That was
And we
really
can-
my concern.
And we
But-
can even separate it and put the family law part of it out to July, a couple weeks after. I have no problem with that.
Well, I don't want to go too far. My concern with that is currently the doing so. So on the case with the older children are 17 and change. They're currently prohibited from seeing their father at all. And there's a lot of issues with that, with children who have a lot of agency and can do things independently of both parents. So sort of saying, hey, we'll just keep banning them and set that out a long period of time. I don't want to do that either. So my thought is to do to have, let's see, the court do the DVPO on the 14th. Because that was looks like that was what was available for your honor. And then it sounds like you're not available on the 25th.
Correct.
So maybe either, and I don't know if the 18th is too soon for you, or the 2nd of July would be kind of my thoughts on dealing with the domestic side of things.
I can do the 2nd. I can't do the 18th because I'm not gonna be in the office. I'll be working remotely. My son has camp in Portland. If we can do July 2nd, that will work.
That would be good for me. That will give enough separation, plus we'll have some time in the middle to kind of review everything on the family law independently. So if we move this to the 2nd, these cases, we'll address the protection orders on the 14th, and then we can, if we don't want to adjust something, we can also do that on the 14th.
And we may not even need to set the hearings on the 2nd at that point, depending on what occurs. I mean, who knows? We could even settle before then. So, which is still always the hope of everybody.
And then I did have one additional request, which time-wise, depending on if and when your honor wants to hear it, my client had, because the boys in this case, in the Ramos Shirley matter, the boys are 17 and change. It is unique to have children that are about to age out, and where a guardian ad litem report at 120 days is going to bring them a hair's breadth away from being 18. I had proposed that we should appoint them counsel, where you have a whole lot of adults saying, kids said this, kids said that, this is what kids want. Maybe we should just get it from the horse's mouth. And so I proposed that we appoint them counsel, because given their ages and essentially ultimately what's being decided upon them, and an order that can't even last for a year because they're going to arguably age out of a protection order, and it gets to an odd place.
And your honor, I would ask that we reserve on that, and so we can present argument, because I think the GAL is the appropriate person for that. And I think her report is, I'm not sure if she's here today, but I think she mentioned she was going to have her report done very soon. I haven't seen it. So
There's
I
no
hate to have
GAL
more.
in that case.
Or there's a GAL in the other matter, and I know she's talked to everybody considering the cases are together. I would just ask that if we can reserve that for, even if your honor wants to make a decision off docket, so I can just do a little bit of briefing on that.
There isn't a guardian ad litem in the older children's case. And so because there's no guardian ad litem, there's been no guardian ad litem appointed in this case, in the older children's case. She isn't a representative for them. And I don't think that that's an appropriate vehicle. There's a statutory process for that should be followed. So again,
This is Nathan and Judah, correct?
correct.
That's correct, your honor. And you'll see and my concern is you'll see the missed calls last filing in this case, talking about how one of the children disclosed threats of violence by the father to him and about his other family members to him. And so my concern is that obviously an attorney is important, but I also consider that a GAL might be more appropriate in this case, given that all of these parties are the same. We have the same dad. We have two different mothers, but we have half siblings that are all related. The GAL's already talked to everybody involved. My concern is forcing these children or these 17-year-olds to speak to yet another person. That's just my concern without any briefing. Had I known that, I would have had something ready for your honor today.
Let me do this. I'll address that essentially off docket, but we'll discuss it on the 14th when we're here. If you want to file something, go ahead and do that. Send me bench copies, as well as obviously the council. And these cases won't be on the 14th, but we can discuss it at that time.
Okay, sounds good. Thank you.
That would simply be the issue of whether or not they should have an attorney.
Right. Okay.
Sounds good. All right.
Okay.
Thank you, your honor.
Very good. Thank you. All right. So at this point, just for clarification for myself, Mr. Sasaki, you came in kind of in the middle of all this. And you're only involved in the 24-10908 matter, I believe.
Yes,
And-
only with the older boys.
Right, just for Nathan Ramos and Judah Ramos, and it was my understanding that I was also in the case ending 7-0.
That may be, I think that's true. I don't have that necessarily in front of me today for some reason.
That's my understanding. So I think the declaration that was at issue ended up being filed into both files.
Okay,
So I think we appointed him into both.
okay. Okay. So procedurally, we've got a number of things going on. One is we had a review set under the 24-394-08 matter, which was I'm going to go ahead and admit Ms. Call on that because that's on a review for her to file her report, which she has done. Did you all get a copy of that?
Yes.
You probably didn't because you're not in that
Did
case.
you copy the guardian ad litem report?
I did not.
Because that's in the other case that you're not involved in, so. Ms. Call, are you there? It looks like you're muted on me there. If I can get you to unmute.
Good afternoon, Your Honor. I apologize.
Oh, no problem. So this is, let's take that one first. 24-394-08, that's the dissolution. It looks like that was on today for final GAL review. It looks like you did file your report on that.
That's
Yeah.
correct.
I'm not thinking there's anything else pending in that matter today.
Not
Am I-
today.
That's my understanding. So at this juncture, I think we've got, we do have that, so I don't know that we need. That's the only issue on for today was to make sure that was done, and that is done.
Okay.
So I think until you get notice on some other motion on that case, that should be everything on that we have on that matter today.
That's correct.
Okay, so
Okay.
that brings us to the, so you're welcome to stay or welcome to go. It's up to you. On the.
I'll probably stay out of curiosity, to be honest.
Okay. So I've got the two cases. One is the Nicole Ramos matter, which is there. Okay, so that's 24-29608. That's the one that something happened here. Oops, I know what I did. My bad, sorry. Clicked the wrong thing there. Okay, that's the one Mr. Sasaki's involved in, so let's address that first. So we're set on for hearing on both of these protection orders. I did have a chance to go through a volume of documentation that was filed in both cases. And so I guess, how does everybody want to proceed today?
So at this point, they are the moving parties. So I would ask, because Mr. Sasaki is only involved in the Shirley v. Ramos, I would think we should take that first. And then sort of Mr. Sasaki can decide if he wants to stay or not, sort of when that piece is concluded. And then we can move into the Ramos and Ramos protection order. And then move through that. And then we had scheduled for today, and then we're also scheduled for, I think now Friday, starting at 10. And so, at least that's what I was told. And so, my proposal would be, the petitioners present whatever evidence they intend to, or if they don't intend to, I'm not sure. And then if there's something new besides what's just in the pleadings, then we would ask to respond in writing and then make any final arguments on Friday.
Okay. I've got it set. I'm just looking real quick here. Yeah, it is set at 10 o'clock. Interesting. Anybody know why it was set at 10 on Friday?
Because I have unlawful detainers at 9.
Oh, I see. Okay. Okay. All right. So let's start with Chantel Ramos it's 24-2-10908. I've read all the documentation that's been filed. So do you want to testify today, or do you want to just simply argue the case? And then Mr. Sasaki, I don't know what your position is on behalf of the two boys.
I have a few questions for Chantal.
Okay, all right. So, ma'am, what I'm going to have you do, if you want to pull the microphone over a little bit, I'm going to have you raise your right hand for me. If you could, you just there you go, like that. You promise to tell the truth today under penalty of perjury.
Yes,
Okay, and for the record, you are Chantel Ramos?
no,
Shirley.
Shirley.
Shirley. I'm just legally, I've got it in my case here. It's Chantel Ramos still. So Chantel Shirley. And you're the petitioning party in 24-2-10908, correct?
Yes.
Okay. And is there anything, again, I've reviewed your petition. I've also reviewed a fairly large volume of documentation and declarations that were filed on both sides of this case. So I guess have you had a chance to review all of those that have been filed?
Mhm.
Okay. Anything you'd like to tell me in addition to your statement and your petition, ma'am?
The only thing that I can think of right now that you probably haven't seen in here is the ex parte order that was just recently filed. Those pictures are not even pictures of my property. And the young man that did the declaration is going through a lot at home where his mom has recently lost her job and things like that. So, I mean, my assumption would be just like Mr. Ramos attempted to pay off the guardian ad litem, that he also offered that young man some money. And he did a declaration. He probably got his pictures from Sharp Property Rentals. He does a lot of cleanup stuff for them, so it'd be easy to get. But no one's made a visit to my home ever. It's always been an allegation that it wasn't good enough, but no one's ever came. So Nicole's been to my home and seen that it's not what those pictures looked like, and I didn't abandon my children.
Okay, so I did see there was a motion that was filed. I think Judge Hahn may have addressed that.
Yes, it ended up being signed by Judge Hahn.
All right, this was the motion. This was filed July 18th, last Thursday. Okay. Okay, so what I'm hearing you tell me is that the pictures that are attached to that motion are not your house?
No, they are not.
Is there anything else about that motion that, again, that was, again, not before me today.
Zion in that motion states that there's never food in my home. And I promise you, I can bring you grocery receipts. There's food.
Okay. All right. All right. Anything else about, and I'll certainly take that into account. Anything else on I guess the prior documents that were filed?
All I can say is I understand my children are almost 18. They have 6 precious months left before they're allowed to make their own decisions legally. At this time, they both think that by staying with their father, that they can manipulate him into making better choices. So for example, Judah believes that had he been there that night that dad assaulted Nicole, that he would have been able to talk him out of it or calm him down. And that's not a good place for a kid to be. That's not fair. I also understand that they don't want to move to Utah with me, and I understand that. But there are other options than dad's house. Like Nicole would let them both live with her. I don't think Nathan living with her would be wise, but Judah certainly. Her and Judah have a very strong bond. She's been in his life since he was a kindergartner.
All right, anything else?
Not that I can think of right now.
Okay. I go to Mr. Sasaki first. You said you had some questions.
Thank you. So, first, Ms. Shirley, thank you very much for driving the boys over to our office so I could interview them.
Mhm.
I really do appreciate that. Regarding your house, the, the boys or one of them did mention that it was sometimes untidy due to there being many animals. Can you just, is that an accurate statement?
We have a farm, so in the winter months, it gets muddy outside. And sometimes kids track things in or children don't pick up after themselves. Sometimes the mom has to intervene and say, hey, come on, guys, let's clean up. My boys specifically have been raised in their father's home where it is a woman's job to do the cleaning and the tidying solely. But in my home, that is not the case. Everyone's held accountable for their own mess and asked to clean up their own dishes, do your own laundry, be self-sufficient. They definitely, especially Nathan, struggle with that because of the example that he has been shown.
Thank you. Regarding Judah's declaration, there's some indication that Judah neither wrote that declaration nor did he review it before signing it. Can you please explain who wrote the declaration and how it was signed by Judah?
So Judah did write the declaration. At the time that he did his declaration, he felt safe. He was in my home. He didn't have access to dad. There was no manipulation, no threats, nothing like that. Now that he does have access to dad again, and don't get me wrong, he loves his dad. They both do. You can't help but love your parents. Mine aren't perfect either, and I still love them. But now he's afraid to admit that he was defending his mom by writing that declaration saying that I don't let him drive by himself. And I wasn't going to let them get licenses because Nathan couldn't be responsible and Judah's grades weren't good.
In Judah's declaration, it mentions that all of your exhibits were truthful depictions, were truthful. Can you confirm or deny that Judah reviewed all of your exhibits in your declaration?
As far as what do you mean by all of my exhibits?
So in Judah's declaration mentioned that he declared that everything, all the exhibits attached to your declaration were true.
Mm-hmm.
And I just wanted to verify that you allowed him to view all of your exhibits attached to your declaration.
As far as court documents, I didn't allow him to review court documents. That stuff he would have heard directly from me, but he didn't, I didn't let him read the documents, if that makes sense.
Regarding the boys' schooling, approximately how many days out of the week or month would you estimate that the boys missed of school since moving to your place in February?
I know every Monday they would be late because they had therapy appointments. But that being said, I mean, other than doctor's appointments, anything that I had control of, they weren't missing. Now, were they getting dropped off and not going? Yeah, there were some times that we had to have some hard conversations about why aren't you going to school?
Understood. Thank you. Thank you, Your Honor.
Okay. Ms. Baldwin?
Thank you. Your plan is to move to Utah.
Yes,
You've already selected a home there.
not yet.
When is your move date?
We are hoping to start moving just the beginning of next month as soon as possible.
So within the next 2 weeks or so.
Yes.
And you agree neither child wants to travel to Utah at this point?
Travel or move.
Move.
Those are two.
Neither child wants to move to Utah.
Yes, neither child wants to move to Utah.
And you went to Utah on July 6th.
No, I went to Utah on July 8th.
Okay. And you returned on or about July 21st.
Nope, I actually returned July 17th.
And during that period of time, you didn't allow for the father to provide care for the children.
You need to be specific. What are you talking about? I didn't allow.
Did you tell my client or your attorney or Mr. Sasaki that you were not going to be home?
Nope, I didn't think that it was necessary to tell. I had my mother and my son at the house with them.
And you currently work?
Not right now.
You agree that the boys' grades are all D's and F's at this point?
Yes, I do. They were also all D's and F's
Wait for my
before.
question. You had a prior order with Mr. Ramos in 2012, final parenting plan,
Yes,
and you were represented by counsel when that order was entered.
I think so.
And an additional order was entered in 2015.
Yes,
Neither of those orders request a protection order.
I believe in 2012 and 2015, we requested, but were denied.
I don't have any further questions, Your Honor.
All right. Anything else that you'd want to say in response to those questions?
The only thing I want to say is that, like I said before, there are other options than dad that are safe. Nicole, my mother, 2 of my sisters, and my brother, or even their older brother, or foster care would be safer than dad.
Okay. So that, I guess just a couple of clarifications. This is a protection. This is not the custody case or the family law case. This is purely the protection order case I'm dealing with today. Which really is whether or not Mr. Ramos has contact with you or with the 2 kids. Just a second, let me double check something.
And I'm going to ask, although these parties are separate, they can't advise each other during the hearing.
All right, you two need to you're just presenting your own case because we've got 2 separate cases and neither of you can represent the other. Let me just, I'm gonna check something real quick here. Right, so yeah, the order applies simply to you and to Nathan and Judah.
I understand that. I'm just speaking on like their safety as far as like being allowed to stay with dad or even being around dad. He's very manipulative. It's just, it's not a safe. There's a whole booklet here to tell you he's not safe. It's not safe. Can you make this book about me? No, there's nothing. I have traffic violations. That's it. I've never hurt anyone in my entire life in the ways that he intentionally hurts people. His kids, his spouses, everyone. Like no one is safe from him. That's why I'm moving. I have to protect my daughter. And she's not even his.
Okay. All right. Um,
On this case, I'm ready to proceed to argument, if Your Honor is interested.
sure, that's fine.
So you have to start in any DVPO, you have to start at the beginning, which is her petition. And even her own petition doesn't allege any contact, any activity, anything with her. It says essentially something happened with a third party and that my client called the boys and made threats to the boys. But we now know that neither boy has endorsed that statement. And the declaration signed by them or signed by Judah. The attorney has come in and said that my clients are not validating that, and not agreeing that those statements occurred, that my client made those statements. So Judah specifically is saying that's not, basically, I didn't intend to sign that. I didn't have that information. And we do have the declaration from the friend that says he was essentially tricked into signing it, told it was one thing when it was completely something else, never reviewed it. And the idea that a child wrote that statement, that is a boat that does not hold water. And there's no way a child wrote that statement. It's full of legal terms. It's full of legalese. An attorney wrote that statement because that was convenient. A child signed it without looking at it because he's a child and he did what his mother asked him to do. So we have a initial petition that doesn't make any allegations that my client did anything to Chantel Shirley whatsoever. Instead only says there was this call that happened between my client and the boys, which now no one is supporting that statement, nor does she even say that she heard or overheard the call. So when we look at the petition itself, the evidence absolutely fails. From there, you get to the evidence that they've subsequently just piled on, just absolutely. This is a sheer example of, I mean, this is a single DVPO file. That's ridiculous. And 99% of it has nothing to do with Chantel Shirley, has nothing to do with these boys. It's just, well, I'll take things from that case and I'll just shove them over here. And if I say he's bad enough times, then the court will believe it. Even the claims she's making now are, I'm going to move away to a different state. And you should put the kids in foster care. That's not appropriate. The claims that she makes that he manipulates the boys, that's not a DVPO situation. But the claims that she makes here is, essentially really making claims that are parenting plan claims, but they are not DVPO claims. Additionally, she fully admits that this was all previously litigated. She says, I made those claims in 2012 and I made these claims in 2015 and the court denied it. So she's essentially acknowledging this has already been adjudicated twice, found to be lacking. She has no evidence to support those statements and the court already tossed those out twice. So we have two separate prior adjudications where even she claims, hey, I made those statements previously, and the court ultimately did not enter 191 factors, did not give me a protection order, did not give me a restraining order, and then gives not anything that has happened between the 2015 order and now, except things that happened to other people and this call that she alleges that happened between my client and Judah, which Judah says that's not what happened. So this DVPO cannot be sustained. It just is not appropriate, and it doesn't make any sense. We're not arguing the other case today, so I won't get into what the parenting plan should be, but there should not be a DVPO entered regarding my client and Chantel Shirley or my client and the children of this case. It does not make sense. The evidence does not fit. And then we have two prior adjudications where essentially all those claims have already been reviewed, decisions rendered. So the only new thing here, the only change of circumstance is this one claim about my client and the boys, and that claim doesn't hold water. So given that, I'm asking the court deny the request for a DVPO regarding her as well as the children. And again, she's moving away anyway. So we're in a case where she's literally just going to move out of state. So my client does not intend to have any contact with her whatsoever. And similarly, when you look at the files, she isn't afraid of him. We have a situation where one of the claims is that he violated, she literally takes kid to the soccer field where my client is, sees my client, drops the kid off the car, out of the car. Of course, kid goes and sees dad. This kid's like, yay, happy to be around dad. And then she calls 911. If you're actually afraid and you see my client on the soccer field as he's coaching, you take your kid and you drive away. You don't say, get out of the car, kid, go create a violation. And that's really what we have, is we have folks that are trying to spin something where nothing exists, who are essentially coattailing on to another case. There's an ancient proverb that the enemy of my enemy is my friend. And that is certainly the case here. So we have two people that will falsify documents, get children to sign statements that they didn't write nor reviewed. Her own, and you can even see it in her own testimony, because she fully admits when Mr. Sasaki says, well, did he actually review those documents before signing, that he reviewed them and say they were all true? Well, no, I didn't let him review them. Well, then how could he say he reviewed them and they were all true? So even she's acknowledging that she's required her child to sign something that wasn't true. So that speaks a lot to the veracity of these folks. The fact that she leaves kids home, leaves the state entirely, and very concerning about these children and being left in conditions that are not appropriate. Children's grades have gone from not great, but they were doing okay, to now every single class is at D and F. And so we're not only is this order appropriate, it's causing harm. And so I would ask that the court deny the order. The evidence just does not, it certainly does not get you over the 50% threshold.
Mr. Sasaki?
Yes, I had an opportunity to speak with both Nathan Ramos and Judah Ramos more than once. And both on a one-on-one basis, as well as three of us together. And I can confidently say that according to Nathan and Judah, that they state that they've never been abused, they've never been threatened, nor have they witnessed any other party being abused or threatened by father. And based on the pleadings that I have reviewed for them, I believe their statement. That's all. Thank you.
So do you on their behalf have a position on the no contact order?
Yes, I do not believe it's necessary as to Judah and Nathan is what I can speak to.
Okay. Any further comments from you, ma'am?
Yes, so I would like to talk about the night that he assaulted her.
I want the argument about the facts, because I've looked at everything in the case. So
Okay. This is about the facts.
Okay.
So when Mr. Ramos and Nicole got into a physical altercation on February 2nd, instead of calling the police, he actually called my son Judah and said, Mijo, I need you to come to the house. Nicole's fallen and hit her head, and she's going to say that I did it. Let's fast forward a little bit. He's telling his son at the same time to the same day, come over and tell the police that I didn't do this. Come and protect me. That's the whole attitude that he has about everything. Everyone in that house is supposed to protect him at all times. He also called my son from in jail, Judah, from jail. I was sitting right next to him. Ask your mom to bail me out. You need to do this. If she doesn't bail me out, she's going to pay. Little does he know, I'm the one that called the police when he called my son. And then when he gets out of jail, he has me bring my boys to go and meet him, and tells all three of us, you're either on my side or you're not. Whoever's not on my side will pay. I'm sorry, does that not sound like a threat to your own kids? That is a threat. Not to mention, he says in text message several times, these are right after everything happened. Go upstairs and tell Nicole this is your house and you're going to get your stuff. She's going to pay for this. How is he not putting his kids in danger by bringing them into this? Whether he directly threatens them and says, if you don't do this, XYZ is going to happen to you, or goes and gets them in trouble because he convinces them to go and do something against her that gets them in trouble. I'm not saying that I don't want my children to go with me to Utah either. I'm just saying I want them in a safe environment. If that can't be with me, then can you please find somewhere? We have lots of options that's safe until we get this figured out. I understand they want to go to school with their friends. It's their senior year. I do not want to take that from them. But sometimes as a parent, you have to do hard things. And also, just to go back to the time at the soccer field, when Nathan and I arrived at the soccer field, there was no one there. He specifically asked me, hey, Mom, can you take me early so I can warm up? And I said, yes. And then I just had a weird feeling. So I drove by the soccer field and there was his dad's truck. There was nobody there at all when I dropped my son off.
Okay. I guess process-wise, I think what I'd like to do is, I'm going to take a short break. I'm going to take a look at a few things, and then I can come back and give you a decision on this case, and then we can look at the next one.
Okay, very good.
Okay. So it'll probably be at least, I would say at least 15 minutes. So maybe about 10 after on that clock up there. So it's maybe about 25 minutes. I wouldn't normally take that long, but I got a lot of stuff. I want to go dig a couple of specific things out before I make a decision. So do that. Thank you, everybody, for a short break to relook at some things. This is a very difficult case, and it's difficult in large part because of the volume of information that's been filed in the case, some of it kind of cross-filed. There's a great deal of information that probably doesn't directly apply to this case, but there's just a lot of information. Sorting through that has been a challenge. I did over the course of, well, since his case started back in, they started back in February. I reviewed documents as they've come in and exhibits as they've come in. And then when we recently appointed Mr. Sasaki to represent Nathan and Judah, in part because of allegations that were being made, I thought that was important to have their specific interests represented, since they are almost 18 and do seem to have some strong feelings about the case. In reviewing back to the petition and the allegations that are made in the petition, which is kind of where this all starts. And there's some allegations made. Mr. Ramos has denied those allegations. And really, this case focuses essentially on this phone call allegation with the kids. And what I'm hearing today, and I've seen it throughout, I'm hearing today both from their attorney as well as the declaration filed by Mr. Van Hook that at least Judah's not supporting that situation or that allegation. And then there's a number of things that are, and people very well have a lot of concerns in the case. I did go back, and as part of this case, in part because there's this kind of cross-linking of this case with the family law case, did go back and look at that. And It's a case where the fathers had custody of these two kids for a good portion of their lives. Without real specific restrictions. There are some notes in, I believe it was the 2012 order in the family law case. And again, that's filed in a declaration in this case, but it's also part of this court's record, so you can take judicial notice of that case. That both parties had some drug testing and there was some other concerns raised. They didn't raise to the level of 191 factors because they weren't listed that way. And at the end result of that, both parties being represented, the father had primary placement of the two kids. So again, in distilling all this down, it's not an exact science because I've got the same notebook that y'all have there, and I've gone through that a couple of times. As it relates to this case, the 109 matter, I am not inclined to enter an order. That doesn't necessarily direct the family law case. That's a separate issue. I think will need to be dealt with separately. But I think as far as the this case, I'm going to deny the order. So
Does your Honor have a denial order? Do you want me to prepare and provide?
probably going to need one. I don't.
Okay.
If you want to do a bench one, we could probably do that. I guess my question then is, Mr. Sasaki, you're certainly welcome to be present at the other hearing that may have some effect because you're also involved in the family law case. I don't know if you plan to do that or you had a desire to do that or do not have a desire to do that.
I did have a question as to that.
Mhm.
So it was my understanding that the family law matter was, according to the documents that I saw, was going to be today as well, and or on Friday, this Friday. So I wanted to clarify the family law, the next family law.
I don't-
Hearing, that's the case, 09300722-0.
It wasn't set for today. Today was just for the two DVPO cases.
The issue really is there's, and this is part of the complication of this case, these cases. We have two protection orders, which has this volume of information that you've received. My concern in addressing both of those cases at the same time or even close in time is there's a significant amount of information here that's likely not admissible in the family law case. There's a lot of hearsay that is admissible here that's not admissible there. In part of my concern in this case, I've expressed this a number of times, you haven't been privy to those hearings, is being able to kind of parse that out in my head. And so I'm concerned about the family law case. And I don't even, we've kind of been tracking it along to see what happened here. So that's still pending.
So as of now, that
Oh,
next hearing date is
not set, but I'll make sure that I notify you once it is set.
It'll need to be set because there are I think there's some temporary orders in that case.
I'm
not sure where that's at.
That case has expired, so now they would just be back on back on the last final parenting plan. I'd have to verify, but I do believe last time I checked.
That may be, I haven't looked at that case because that wasn't really pending, but that's a case that is still pending before the court. Obviously, there's a petition to modify in that case. So,
And to answer your question, Your Honor, I wasn't planning on attending Ms. Rollins' protection order hearing. That was your question, right? For
Correct.
Friday. But if it pleases the court, I couldn't object to appearing. I would need to double check my calendar. Well, actually, I am for them.
okay. You're certainly welcome to. I mean, obviously, there's information that may be germane to that case, but you're not required to.
Then all due respect, I would will not be appearing then.
Okay.
Ask if I could be discharged in the orders forward.
We can include that in the order. Again, you were appointed specifically for this case, I believe also in the family law matter, but again, that's not scheduled for today.
Thank you.
Okay, so I don't know, if Ms. Baldwin, if you want to do an order up or,
Benfer, I'm happy to fill one out.
maybe you can all put your heads together and put that one. I guess my thought then is as far as the other case, we've put this order together, get this resolved. And then we can make a decision if you want to proceed on the other protection order this afternoon. We have the balance scheduled for Friday. I don't know if we're going to need that. That's a more complex case, I think.
I think that, so my preference on the other case is to allow Ms. Nicole Ramos to put whatever evidence she wants to put on today. Then I can present my client's rebuttal to that just via declaration, and then we can just make final argument on Friday. So then Friday would just be most likely about an hour.
Okay, that's fine. Why don't we'll take a short break, put this order together, and then Mr. Sasaki, you're free to stay
Can
or
I
go.
ask a question before we
Yes,
take a
ma'am.
break?
Mhm.
So we have 2 family vacations coming up. One is August 10th through the 18th.
I'm sorry, we have two.
We have 2 family vacations coming up. One's August 10th through the 18th, and then the other one is in October. I don't remember the exact dates.
Okay.
Do I need to file something or do something to make sure that the boys can still attend those vacations? And I know for sure that they do want to go.
If that's agreed, they don't have to do anything. If it's not agreed, then we'd probably need a motion filed.
And when you say agreed, do you mean agreed between mom and dad or agreed between the kids and us?
Well, I don't know do you know what those are?
She can email me and then we can address it. But it can't be, what she's asking you is, can my 17-year-olds just agree and then we can all just violate the underlying order?
I was
So to that-
asking
to
for
that I would say no.
clarification, not.
Well, I don't know what the family law order says about those things. If it's a vacation time that's already covered by that order, then
It is.
okay, if it's already in the order, then
Okay,
that you'd be fine. You're still under the old order
okay.
because we haven't changed anything in that. And I don't know if I've got that handy here. Let me just take a quick look. I don't know if there's a. Don't.
There is a set summer schedule in 3.5 of the 2015, which is the last final parenting plan. So they would just need to abide by that.
And we haven't done any orders in that case, I don't think, other than,
Essentially, my understanding is in the parenting plan modification, we'd entered a restraining order that has since expired, that was essentially just resting on this case, for this case to play out. But I would normally enter, or I did not, or an order changing that, but it's already expired, I think by time.
yeah, I know there's a petition filed and it's pending, and Mr. Sasaki, or you were appointed in that case, I believe, as well. That's the 093722 matter.
Yes.
Okay,
Yes,
so I don't think we have any temporary orders in that case, but I don't see
I
anything
don't
here.
believe so either.
I don't believe so.
I believe that September 2023 was the last.
So whatever the current order is that's what would govern those vacations.
Okay,
So if there's some disagreement on that, then you can't work that out. We'd certainly be happy to take a look at it. Okay, all right, so I'm gonna step off for just a few minutes to get the order done, and then Mr. Sasaki, you can go about your business once you let me know when you're done. And okay, all right, so let my clerk know when you're done. We will adjourn for a few minutes on this case, and we'll come back and we'll address the where did it go here? I'm just looking for the number here, the 24-296-08. I think that's the right one. Yeah, that's it. Okay, so we'll be right back.
Thank you.
And as far as the family law case, that I assume will be set in due course.
Is it okay to do the family law case via Zoom?
I'm sorry?
Is it okay for me to do the family law case via Zoom?
Those dockets are all hybrid, so you can either be here or be via Zoom.
Okay.
If you go to our court website, there's a link for whatever day it would be on for my docket, to be the family docket in the afternoon.
Okay.
Okay. All right. So brings us to 24-29608, which is Nicole Ramos and Jose Ramos Curio. And again, this is a case where I did have a chance to go through documents that were filed. And so, and just for the record, and this is just taking kind of judicial notice of where we sit, we've got 3 cases pending that are all sort of related around this. One is the criminal matter. There is a no contact order in that case. It's 24-185-08 that does prohibit contact with Ms. Ramos and does have some limitations on contact with the 4 children. And then those are also addressed at some level in the family law case 24-394-08. And I did note when I was looking at that case, there was an agreed order on reunification counseling that was entered. That must have been done on that wasn't something I did. Judge Bassett signed that order. Is that, I assume, is still in process.
No, it hasn't begun. We
But
can't
the
we
orders.
can't get compliance.
Okay, so but that's in the family law case. That order is in
Yes.
place. So,
Correct.
and I know we have there is some visitation set out, and I think that Ms. Call is involved in that case and has filed. Well, we just confirmed that that was filed just for today's hearing. We haven't had any hearings on that issue. So given that, we're then looking at the civil protection order case today, which is the 24-2. One here, sorry about that. 24-29608 matter.
Correct.
And Ms. Ramos, I assume you're still pursuing that order?
Yes, Your Honor.
Okay, and if I can have you raise your right hand, please. You promise to tell the truth today under penalty of perjury.
Yes, Your Honor.
Okay.
Before we commence, at this point, Ms. Shirley's case has ended. And so I would ask that she not sit at council table at this point.
Right. If I just have you sit, you can stay in the courtroom, but you wouldn't be at the council table because it wouldn't be your case. So. Right. And so, ma'am, you filed a petition for order of protection back in February, so February 6th to be exact. And that contains a number of statements. Is that accurate?
Yes, Your Honor.
Okay, and are those statements true and correct to the best of your knowledge?
Yes, Your Honor.
Okay. You also, through Ms. Winkle's office, filed a variety of declarations, exhibits, and that sort of thing in this case as well in support of this. Is that right?
Yes, Your Honor.
Okay. So, and I have had a chance to go through all the filed documents, all the appropriate exhibits. So let me hear what you have to say today.
I just wanted to start with the no contact order that was from February. That's why I'm asking for the protection order. And that's not the first of the domestic violence where the violence began. As you've read through all this evidence and the documents, one that I wanted to point out was when I actually first met Mr. Ramos at Fiber Credit Union. And over the course of a year, they did document that they were seeing that there's been a lot of domestic violence. And then it was actually starting to cross over to the work environment. And they did have to restrain him from the property. Did you read that document?
I did see that. There was some, I think some letters from, believe it was Fiber.
Right, they stated that they've notified by several witnesses. And I don't know if you read through and saw that they have reason to believe that she's in an abusive relationship that has now crossed over to the workplace. Nicole started to cry, but would not say anything. She was visibly upset and shaking. I further advised her that I had concern for her as an employee and also the safety of our entire staff. Therefore, I was going to send Mr. Ramos Curiel a letter notifying him that he is no longer welcome on the main office property where Nicole works. And later they said, you know, that if he comes onto the property, the police will be called in criminal trespassing. This was back in 2011, back from when, you know, because domestic violence can go on for years. And now it has, it's continued. I did not call the police February 2nd. The police were called and he came to the point that he was strangling me and I almost died. I lost my vision. I couldn't speak. There's actually medical records here that show that I lost my voice for almost 3 weeks. It was still, I didn't know that my vocal cords weren't damaged at the time because it was so inflamed. I had went to the ENT and there was so much inflammation. She wasn't sure that my vocal box had been damaged or not. So we were waiting till the inflammation had went down. So this was 3 weeks after February 2nd. That whole time I had no idea if my voice was even going to come back. I was holding my 4-year-old son, our 4-year-old child during that time. That is why, and it's assault too. That's why the no contact order includes the 4 children as well. And this has been going on for years. And I have my Kaiser medical record that I'm sure you got to see a little bit of as well, that there's superficial trauma to my head. This is in 2011. I was 23, 24 years old. I was just out of high school for 5 years barely. I was starting my career at Fiber Federal Credit Union. I was well on my way to be a successful parent and everything, have a successful life and not be subdued to domestic violence, which some women, you know, that's what happened here. And you can follow this whole book. That's why there's so much, is because there is so much, unfortunately. That's the story. And I don't know what to tell you besides that there is proof. And it actually started in 2008. There was concerns from Chantel Shirley. She was being abused as well. But because of his money and his control and hiring attorneys, there's no way out of this, unfortunately. And here I am today, still asking for protection. And I almost died and I had our child, like, and I've been nothing but serving and like being there for him every day so he can run his business, so that the children can thrive and have a happy life and keeping the house in order, keeping everything. There's so much of that. I am asking for still protection. I'm not sure, I don't want to ramble to you. That's part of being abused for so long, honestly, but I'm out of that. And I have a career now. I'm at the Longshoreman Local 4 Federal Credit Union. And one thing that they're concerned with is that I have to take so much time off for these hearings, and that on my lunch breaks, I have to go to these Zoom hearings. Like my lunch will be at 1 o'clock to go to the Zoom hearings, but they go further than lunch breaks. Those are busy times at a credit union. They need me there. I'm more than capable, but all of this is keeping me. That's part of domestic violence, though, to keep you in it, to take the children from you, to use that as control. And so here we have the guardian. That was that's why she was appointed, was to get a professional opinion and not have so much drama and all of this stuff, so that you could get a professional opinion from someone that would meet with both parties. And her conclusion, her recommendations, you've read that as well. She does recommend, and I recommend this as well. I don't, that's the reality of what we're in. And I do want to protect my children. I feel that I have to. I almost died, and that's what I'm here. God kept me alive so I can protect them. And it's, like all I can do is show you and talk with you and tell you what, and it's your decision in the end. But she also recommends the same, that the children should not have visitation with him. So, and I also, all of this stuff I agree with. I agree with that. I've been abused for a long time. It's time to move forward. It's time for him to be held accountable for his actions and to stop putting so much drama and ruining other people's lives just because you don't want to be held accountable for it. So I don't really have much to say. You don't get to see him abuse me, but I have a polygraph right here that shows that he has and has been. I don't know what more I can show you to show that I do need protection from him. And if I don't, he will find the moment that, and like he's said in the videos, like he's said this multiple times, and he is very clever, that he will wait for the opportunity. He's not dumb. He's not going to kill me right now. He's going to wait for the opportunity and no one will know it was him and there will be no way to prove it. And I believe that 100%. And I do need protection.
Okay.
There's more to this but I know that you'll probably say it's not appropriate and all these things because of the immigration things. And like the reason why he married me 2 years ago, yet we have a child that's 12, was for me to petition for him to get his green card. And I am working with him. I've been there with him, trying to do everything for him, to please him, but it's never gonna be. That's part of this domestic violence. And if he's not held accountable for his actions, he's never gonna change. Another woman, he's gonna find another younger woman, because those are the weaker ones that you can manipulate, you can gaslight, you can blame shift all you want, and people will believe it. It's fine. That's how they get away with it. It's okay. But I'm alive and I'm here to tell you what happened. And that's like, I don't want to keep talking. I'm sorry. So,
That's fine.
yeah, that's basically, you have this binder too, so you can visually see and read and know, facts and things that aren't hearsay and, so I do still ask that I get a protection order and that we were protected and that the children are protected as well.
Okay. Any questions, council?
No, but I guess questions for your honor. Previously there was several videos and then there was a motion about which videos should be reviewed and which ones should be excluded from evidence. Did your honor ultimately make a decision on that? I know that, I believe the last time that it was before the court, you were gonna review the videos and then decide sort of which you were gonna consider and which you weren't.
I have not viewed those,
Okay.
Because there was a big challenge there, as to what was appropriate, what was not appropriate. And I reviewed both of the legal briefings on them, and I mean, it's an interesting issue and somewhat complicated.
And then in addition, we had sent a video, so that we just asked that that be included, in the consideration. I don't think there are any objections to that video.
I believe I have all of those. I have one from the Swinkle's office. I have two from the Swinkle's office. I don't know if I had one from you.
I think in the past, my office resent it.
Because I just have these two. That doesn't mean that there isn't another one that, wait a minute, hold on, I do have one here.
We sent ours.
Does that look like,
I can't tell you one or the other.
just says judge on it? Wait a minute. And clerk.
I will have my office send it to you via Dropbox.
Okay.
And we'll resend the petitioner copy as well.
I did have, well, but just a second here. Yeah, I've got one in, I'm not sure. I assume these are the same way. They're one for each. So there was one from the Swinkle's office, and then I assume these are from yours because we left with regard to these two cases, and one's marked clerk, one's marked judge.
And then I did want to address, there's just one additional video that that's unique. Because my office represents a client in criminal matter, we have the CJAC video of the children. And so they did do a CJAC video of the children. Interestingly, the prosecutors entered a protective order in the criminal case, but they essentially didn't fill in any of the blanks. So the order is not effective in actually protecting anything. But in the spirit of the rule, we haven't disseminated it. What I would suggest is that I think it's because that's so relevant to the issue at hand. What I'd like to do is enter a bench order that we can provide that for your honor to review in camera, but that's the only person who gets to review it. Because I think if the judiciary is reviewing the order, I'm not even breaking the spirit of the law in that sense.
I think I'm not opposed to that, but I would want to have something from obviously there's an agreement between your office and the prosecutor's office. Let me see
They
here.
have to provide the CJAC as part of discovery, and then we signed the protective order, but it didn't actually protect anything, just in how it's written.
Well, there is a protective order that was entered that actually I signed.
But if you read it, like the body is not effective in that they didn't fill in the blanks.
This one doesn't have any blanks. This was
Oh, are we talking about the protective order protecting her, or are we talking about the protective order for the CJAC video?
CJAC video.
Okay.
This is it's document number 18 in case 24-18508.
Okay.
Let me see here. And it limits it to defendant, counsel of record for defendant, listed witness, police officers, defense investigator, transcriptionist, and any necessary witness. It doesn't have an automatic, so I would want to have at least something from PA's office that allows, obviously, non-dissemination language be appropriate, but if it's going to be considered, it probably needs to have that.
Sure, fine with a email attached.
Yeah, just something. I want something that would, first off, I don't have it. So second off,
We didn't send it because I wanted to confirm with
Yeah.
the court first.
so I think before I look at it, and particularly since it's, I guess my other concern on that, I think practically, as a practical matter, I'm not sure I'm allowed to look at something and consider for this case if Ms. Ramos is not able to look at it.
My concern with her viewing it is it can change her testimony at the criminal trial.
No, I understand that.
Yeah.
But you understand where
I do.
I don't think I can look at something and consider it if you both don't have an ability to see it, just like in the criminal case. If you can all work that out with the prosecutor's office, with Ms. Ramos, I'm happy to look at it. I just, with some kind of parameters from PA's office that says they're fine with that.
I'll work to see if we can address that, and then I can present wherever we are, either with a clear argument on the issue or an agreement on the issue.
Okay. Yeah, I'm concerned of considering something that both parties haven't had a chance to see.
I guess, do you have an objection to him reviewing the CJAC video from the children's interview with the law enforcement?
If I need to see it as well, I agree with him that we both should see it logically. That makes sense.
Again, I don't think I'm allowed to consider something that isn't available to all the parties. At least in consideration of a decision. I mean, I'm not doing a search warrant or something.
Right.
For confusion, it might be best to just leave it out. I mean, we have enough stuff. We have a lot of stuff that we.
I don't know what it is. I mean, I know what it is generally. I don't know what it says.
Let me staff that. Let me staff that issue, and then
And you probably have a different lawyer because Mr. Letman was the one who presented it. He's no longer with the prosecutor's office, I don't think.
I don't believe so.
I think
So
he left, so.
I'm sure we're in contact with the current prosecutor. So we'll reach out to them within the next day or two, and then I'll address the issue of her. I'll talk to them about issues with her reviewing it as well, because I have concerns. But all right.
Okay. And so you have no questions for Ms. Ramos?
No, not that I think that aren't already covered by the pleadings.
And did you wish to present any testimony or?
So I'm gonna present that from my client via declaration. So
Okay.
that was, and then we'll argue on Friday.
Okay. And then you can check with the PAs if they, again, I don't have any issue in reviewing it other than I think there's some limitations based on that order that I.
Right,
Fine.
I agree. I would make sure that we have agreement from them and then
Okay.
a specific order in this case that would limit dissemination as well.
Okay. So that being the case, what I would propose we do would be to set this over till 10 o'clock on Friday.
Yes.
To hear whatever else I'm going to hear and I'll make a decision. That'll also give me a chance. I want to go back through some of this and kind of parse out because there is some overlap. I want to make sure I'm looking at the right stuff. Okay.
Very good.
The order that we have, I don't know when that, does that expire today or does that?
I set this one a while ago.
We do have it. There is a no contact order. So there is
Yes.
an order in place in the criminal matter regardless.
Okay. I'm fine either way, just in the sense that there's the existing criminal order.
Just looking at this here. So what I can do here, I can just do a bench extension of this order through Friday.
That's fine.
So I'll just, we'll take a look at that. I just referenced the last order, so, and I'm just extending it through our hearing on Friday. Which point I'll make a decision on further extension or not. Not quite as legible probably as the last order because I didn't type it, but
Mhm.
and there won't be another copy that's served. We can make a copy or you can get a copy from the clerk's office.
That's
if you
fine.
want, but- So
It's
that order
not-
will be
it's
in,
not
a-
making any changes, so.
there's no changes. So the order that's currently in place will be extended through the hearing on Friday. Without changes, and then I will review back through this stack and I will await any declarations and then decisions on the
Then,
CJAC order.
final order of business, so once we adjourn, I would just ask that Ms. Ramos as well as Ms. Chantel Shirley exit the building. I'll stay with my client for 10 minutes or so. I just don't want there to be any crossover.
Okay, yep. So he'll stay here, give about 10 minutes for you to go ahead and exit, and then we'll reconvene. I assume it'll be in this courtroom, but it'll be in one of the 3 courtrooms on Friday at 10 o'clock. Okay.
Thank you.
All right, you're welcome.
I don't have the hearing from the presentation docket where they finished the testimony for the restraining order, but we can see in Odyssey that the judge signed the extension.
Okay, Ramos, Curiel and Ramos, 24-3-9408. I saw Miss Baldwin is present and we have Miss Call present. Heather Call.
Present.
Yes, I'm present, Your Honor. I'm here.
There we go. Okay.
Sorry about that.
All right. So this was on for review, I believe on this big case. So it takes a minute to load. Give me a second here. We're reviewing for, it was just a review. We didn't have a specific, but we also did have a presentation. And that, this is an interesting case. I got a proposed order from Miss Baldwin. I assume that also went out to Miss Ramos.
It did.
This had to do with the March 26th hearing. And when I got that, I didn't realize that was actually noted on for hearing, so I didn't see the note for hearing, but I did go back and review the audio record. And so I didn't believe that the language in that order synced up with the actual audio record from that hearing.
And so it's been some time, and I'll just ask, so what happened was all 4 children were ordered to have visits with my client. So there's 2 sort of grade school age children as approaching sort of middle school ages. And then there's 2 younger children that are sort of preschool age children. The mother claimed there was an issue at the very first exchange with the I'll call him not the toddler, but the preschool age child. And then the court then said, okay, well, there's some issue, and then stopped visits. My understanding was the court did not intend to say nothing ever, but that the court intended to have these video visits pending some kind of counseling or something, getting back together. Obviously, it's been some time and a bunch of things happened intermittently. What was your Honor's intention? Because it's since you just reviewed the record, what did you intend to happen with the 2 younger children?
Well, what I essentially, there were visits with all the kids, and then what I did in that, and I, again, reviewing the record because it was back in, I think it was March, we had that hearing. Here are a lot of things since. What I indicated was that the 2 younger children may have weekly video sessions with the father. Those were going to be, at least one of those was going to be supervised or at least observed by the guardian ad litem. I didn't require professional supervision, as I recall when I listened to the record. And so the issue would be, as I guess, is if we're going to have a video visit, that needs to be synchronized with Ms. Call so she can observe how that goes and then give the court some feedback as to what should happen going forward.
My understanding, Your Honor, was that the agreement in place at that time was that we would have these video visitations at a professional location, that Ms. Ramos would bring the 2 younger children to that location. I did offer to observe a couple of those visits. I was not willing to say I'd be there for every visit because my understanding was that these were to be supervised due to concerns around how the father communicates with the children. Those visits were never established. I did make multiple attempts to speak with Beth Fellows. That was going to be the agreed upon location. My understanding is that Ms. Ramos did not establish and complete what needed to happen for those visits to occur. I do want to point out, Your Honor, we have not had a review of my guardian ad litem report, in which one of my recommendations is that the children have no contact with Mr. Ramos outside of seriously supervised situations. That has not been addressed in this case yet. I just want to go on record as saying I do think there are some very serious things here that need to be addressed.
Hey, so we're here right now reviewing a specific issue about these calls and video visits. And so my clients find that they all be via a professional supervised agency. The reason being that he doesn't want any allegations to surface, and it's just easier to avoid those at this point.
Sure.
By using Ms. Fellows, so that there just isn't any ability for anyone to make false claims. Your Honor dealt with the DVPO of not only Ms. Ramos in part, but also Ms. Chantel Shirley, where there was a lot of claims, and then some of those really did not suss out, and some of those appeared to be falsifications during that DVPO hearing. And so my client is in a position where he doesn't want to have any risk of false claims. So the professional supervision my client is fine with, because right now it's protective of him. So we would ask that we do that. At this point, I don't have any issue with Ms. Call observing some of them. They should be sort of when she chooses to, requiring her to observe like 50% of them, I think would ultimately be limiting on my client. Is that then Ms. Call is oddly, by not being willing to appear, she could limit my client's ability to have a visit. So it should be sort of just, if she desires to observe, that's fine that she can. her observing them should be in a way that in no way in no way disturbs the children. So essentially, if there's like a video feed or something like that, she just should observe in that method, not be in the visit where she's somehow observing it in a way that disturbs the children. I think that creates an unfairness to the children, and it creates sort of an odd situation for the children.
Your Honor, I have no interest in disturbing the visit whatsoever.
Well, all I did was I went back and I listened to the actual record, and the reason I didn't approve this order is it isn't what I said, but if everybody's agreeable to supervised weekly visits by Ms. Fellows, I'm fine with that. And 50-50 split is fine.
And that the 50-50 was part of the order.
That was actually for the guardian costs. That was not for the supervision.
Okay.
I didn't address cost of supervision, so.
Okay.
And that's why I said I didn't sync up with the audio record that I listened to. What we should have in a revised order, and I'm fine with the language, it should be may as opposed to shall. I didn't mandate that happen.
If it's may, then it's not an order. Then mom won't. Then
Well,
we don't have anything actionable.
Okay, so I didn't order shall. And I didn't, because I didn't know what the one of the issues was, is there was an issue with one of the children at the time, not allegedly not wanting to visit. So I was concerned about that. So I have no particular problem with there being a visit that Miss Cowell can observe, and we'll see how that goes. And if I go back and I listen to the actual wording, it was may have up to weekly. It wasn't mandated weekly. So I certainly have no problem with ordering there be at least a visit with Ms. Call present to observe and see how it actually goes. This is a really complicated case. There's a lot of moving parts to it, and the court has a lot of concerns about the whole case, as Ms. Call's obviously expressed concerns. But I think having a visit that the kids can visit with the dad and she can see how that goes and see what the dynamic is would be very helpful. And I'd like to have that happen before we do the jail review, because and so sooner than later, I think we need to get that.
My concern is a single visit allows one party to very much rev up children, and then they have a single visit. Ms. Call observes the single visit, and everything is based off of a single visit, which then encourages parties to behave poorly instead of having a regular, hey, we're going to have once or twice a week, and have a series of visits where then there's children can have a set expectation, and these are children that are of the age where set expectations are appropriate. We're on a review, so the court could say, yeah, but I'm going to make that change today. So even if that wasn't your order previously, you can say that's a reasonable change for where we are now. I think if it's a permissive gesture, mother's already indicated she will decline, and that there will be no visits. And we have young children for an extended period of time. All the studies tell us that absent a substantial safety risk, there should be visits. And my client is fully willing to mitigate those through 100% professionally paid supervision.
Well, why don't we do this? Ms. Cole, what's your availability to sit in on visits at all? I mean, are you?
Your Honor,
you going on vacation anytime soon?
This is what I'm getting to. I'm out of the office starting tomorrow, and then about half of next week. So the week following, the final week of August, I would be available. First week of September, I could do that as well. I'm about to leave town for a few days.
Okay. So why don't we do this? Why don't we put commencing the week of the 19th, sometime through the 19th. I don't know, excuse me, Ms. Fellow's availability. So this will give some time to get that organized. I can put it on for next week for a revised order presentation. So we've actually got the written order in place. And And at this point, I'll order, based on Ms. Fellows and Ms. Call's availability, a weekly visit for, say, the next 4 weeks. I'm not mandating that Ms. Call sit through 4 visits, but if she's available, that would be helpful. And then I'd like to review our guardian ad litem report after she's had an opportunity to do that.
So I just want to clarify. So starting the week of August 19th, and then once a week with Ms. Fellows and Ms. Call can observe as she desires.
Correct.
Okay.
I
and
will
then-
do my level best to be at all 4 of those visits, unless it's just not possible for me to be there. I will do the very best I can to be at all 4 visits.
So
depending
maybe
on time.
kind of let Ms. Fellows know what your availability is, and then she can hopefully kind of schedule accordingly. And then why don't we put this on for review about the 17th of September? That'll give an opportunity to go through some visits. See 1, 2, 3, 4, and then give it, we'll see where we stand at that point. Maybe at 1 o'clock.
And is the court intending for these to be at Ms. Fellows' office with father and children present?
Well, they're video visits, so but it'd be at her offices where the kids would be. So mom would not be with the kid. Miss Fellows would be the one, and then Miss Call can, if she wants to be there in person, I'm fine with that. If she wants to visit or observe via video, that's fine. Whatever works. But mom would not be with the kids when the visit's happening. Dad would be on video.
Very good. So otherwise, I'll use the same sort of form of the order that I proposed, just with those changes.
Yeah, and I think that the order is probably fine, given the modifications we're making today. And then add in the lines about what we just talked about for the reviews and everything else.
I could do that. And then I should be able to get that out today. And then your order is just putting it on for next week.
We'll put it on for next week for presentation, and then we'll put it on for the 17th for review of the guardian ad litem report. And Ms. Call, you can just, if you want to just give us whatever your feeling is at that time, verbally, that's fine. If you want to do some sort of a short update, that's fine as well. If you do a written update, if you could make sure that gets to Kelly, my assistant, and I'll have a bench copy to look at prior to court.
Wonderful. Thank you, Your Honor.
Okay, thank you. And I've got Ramos Curiel 24394-08. Good morning, ma'am. You have a seat there. This is on for presentation, and I did, let's see, I've got that order. Did you get a copy of that order, ma'am? Did you receive a copy of that proposed order for today?
I did receive an email
Okay.
and it specified 3 different sections.
So this was the one that would have, you should.
But I'm not really sure the process of, because Aaron no longer represents me.
Correct.
And I'm trying to obtain some type of legal service through Northwest Justice.
Okay, this is an order that actually is out of a hearing back in did we have this hearing? This was previously, was
I
back in
think originally March was the first one, and then it's slightly modified by the last hearing. So I just sort of left off the date since it's a bit of a mishmash of the 2 dates.
This, I did review back through. This does appear to be the in conformance with the order as we modified at the last hearing. And it does set a review September 17th. I did see an email from Ms. Call, who didn't recall everything on this. This is what I recall, so I'm inclined to enter this hearing order.
Okay.
So I will enter that order, and you'll need to work with Ms. Fellows as far as doing the visitations.
I was actually going to request someone aside from Miss Fellows. I think Charlotte Roos was someone that we were hoping to use, since
Who?
I think Erin was the one that had proposed that long time ago back, because we've been doing this since February.
Charlotte Rosen's doing the reunification counseling, so that's
Right. use her.
That's a separate issue, and I haven't ordered that at this point. This was just a visitation supervision.
Right, to use her for the counseling and for that, to reunify them.
I don't think we've ordered that, though.
It is ordered.
It-
It's previously ordered. It was an agreed order that was entered some time ago.
Okay, I don't recall that issue. The only thing that issues in this one was the visitation through Miss Fellows.
That's correct. That's the only thing we talked about at the last hearing.
But Your Honor, may I say something, please?
Sure.
So why we're here is because of the criminal act that still hasn't been seen, and we're waiting for that for October 22nd.
Mhm.
And I'm just asking that we follow that, because until that has been seen, all this family stuff is really like, you're kind of bypassing because the reason we're here is because I was in abuse. He's being held accountable for his counts, not for me to come into family court and be abused in a family court as well. This is domestic violence still. What is happening in family court is just a continuation. It's not physical abuse anymore. Now it's emotional, financial, mentally, right? So
Okay, well,
he's
let-
being charged, the defendant, he's being charged. Did you read?
I'm familiar with the criminal case.
Okay,
I'm
so it
familiar with-
says that the defendant,
Ma'am,
that he,
ma'am,
can I read this, please?
I-
Did intentionally assault Nicole Ramos, therefore
that is-
recklessly inflicting substantial
Well, I
bodily
certainly
harm
object.
on
Ma'am,
Nicole
ma'am,
and
We're not-
Ma'am,
did assault Nicole
ma'am, I'm.
by strangulation. My life, I didn't have my
Oh,
voice for over
God.
3
Ma'am.
weeks. These are things,
Ma'am,
my son
going
was
to be an contempt
traumatized
if
in
you
this.
don't
I have
stop
been as
talking.
well.
All right, I'm
The
gonna call
second
I'm gonna
account is
call
with a
deputy in
minor.
there. You ring a deputy. You either need to listen or
Right.
you need to not be in the courtroom, ma'am. Okay? I'm familiar with the criminal case. I've read the probable cause statement in the criminal case. I'm totally aware of the allegations in that case.
Then how
I'm
is
aware
it
of-
right to be
Ma'am?
putting me
Okay,
in
ma'am,
financial?
listen.
God, fucking stop, Nicole.
All right, you are gonna
Sorry.
be moved.
That's Ms. Shirley from the prior
That
DVPO.
is not Miss Shirley. You're incorrect on that as
Okay,
well.
ma'am. Okay, we're gonna stop this hearing right now. If I have one more comment that isn't in response to a question, we're gonna have a contempt hearing, and I'll appoint you an attorney for that.
I'm just,
You just need to listen. I'm trying to tell
thank
you
you.
something. Okay, I heard what you had to say. I'm familiar with the criminal case. That's not in front of me. There's a specific order approved by a different judge in that case that allows this to proceed forward.
Right.
And that's all I'm doing. Okay? So I'm not retrying, that's why we're not doing anything until the case is done. We're just following through with supervised visitation.
Right, but the child was in my arms when that happened,
Ma'am,
so
I
he is,
Okay, I understand all that.
so his emotional development is important. And I'm trying to protect that because my emotional development has been hindered so much, and I don't want that to happen to my children as well.
Okay. This is on today for one issue, whether this order reflects what the order from the last hearing. And it appears to me that it does. If you have other issues you want to bring forward for the court to consider, you can file a motion and we'll look at that. Today is for one issue, is whether this piece of paper says what we said when we were here the last time.
Okay, so we're just focusing on those 3.
That's all we're doing today.
Sorry,
Okay.
I haven't had an opportunity to speak with you, so.
Well, you've been in front of me in this case and several other cases numerous times with your attorney. And I've listened to everything. I've read volumes of information on this case. I am probably more familiar with the issues that are present in this case than most of the cases that come before me because of the volume of information that's been provided. And I've spent a great deal of time trying to understand all those issues.
Right.
And I recognize a lot of they're not extraneous, but they're the other things that apply in this case. This is the order that I ordered the last hearing. This is the order I'm signing today. Right?
Thanks. My apologies, Your Honor.
So I've signed that oath. And you'll need to work with Ms. Fellows as far as the video visitations, and I believe you're gonna be coordinating that with Ms. Call, who's gonna oversee those.
Ms. Call's provided her dates to Ms. Fellows already, so they're coordinating that directly between the two of them.
I think that was starting next week or something like that,
Correct.
so. Okay, so that'll be all today on that case.
And then there was 3 things that were addressed there, that the cost be split between us. And that's one thing that Heather had brought up that she didn't, and I also agreed with
That
her.
was what I ordered when we were here
Oh,
at
okay.
the last hearing.
Got
Okay? Okay, so that is all in that case.
Okay.
All right, so we'll move on to the next matter. Thank you, we're good. Okay. Thank you. All right, I'll make, Ramos Curiel and Ramos. 24-394-08. And Nicole Ramos, if you could step up to the, not her, if you could. And this is on for setting a 26I conference.
That's correct.
Check here.
And I just asked the person that's seated with Ms. Ramos to identify themselves.
I'm victim's advocate.
And that's fine. I have no objection so long as you don't give advice.
So, I didn't have a response. Are you opposed to setting a conference with Ms. Baldwin?
No, Your Honor, I've been seeking legal advice, and I just spoke with Northwest Justice.
Okay.
And so he referred me to Wakaikam Legal Aid. And he said to ask for adequate time to be able to respond and to obtain representation with them. He said it would be probably about 3 weeks before I would hear from them. And he said like about 30 days is what he would.
Where are we at on this case,
advise.
counsel, as far as that
And
goes?
because I do want to comply.
Okay, but this is essentially a conference for you to talk to Ms. Baldwin about discovery responses.
Right, and he did say that some of those discovery questions are kind of like a backdoor discovery for the criminal case, and he felt that it would compromise the safety of my children and myself. And that I should seek, I need legal representation.
Ms.
Definitely,
Baldwin?
so.
Thank you. So the simple act of getting a discovery conference at this point has taken months. You see that the original letter that I wrote to her is written back in July. We have additional efforts to just try to get this conference set. And so the request now, and then even this motion is filed mid-August. There's no response. And here we are now in September. The idea that it would take me into mid-October just to get a discovery conference, when I've provided her a letter with all of the issues, point by point, an email with all of the issues point by point. And there's just no response, no communication. And she's just essentially saying, I'm just not going to communicate back. That's not acceptable. It's not reasonable in this case. So I am asking the court to provide the order that I requested, which requires her to engage in a CR26I conference. I'm asking that happen within this week. I think that that's reasonable, especially because I've written a letter with what all of the issues are. So nothing is a surprise. That's been pending since July. And I am asking for fees. I'm asking for $1,050. That's representative of 2 hours of my time. At this point, I've put in a much more significant effort in getting a hold of her than I have essentially any other counsel where I can just schedule it. At this point, we've put in a lot of effort. That takes time, that costs my client. And the answer here is just kick it down the road. That's not a reasonable response for where we are.
Okay, well, I don't think I can grant fees under the rule without there being a 26I conference, but so I'm not going to order fees at this point. I will set a date. Let me see here just a second.
And Your Honor, I have reached out to her office a few times just to keep touch bases and let them know that I am, that I was reaching out to Northwest Justice, and I finally obtained an intake with them, and then I did get to speak with someone. And
Okay.
then Friday I did let them know that he's referring me to Waikaikum.
All right, well,
And keep in mind that I have been starting like the video visits, and so that's been taking up 2 days of the week. I do counseling and the video visits, and the video visits I'm paying 50% for. I'm on TANF now. I don't even get what they're asking me for. So,
Okay. Well, I'm gonna set a conference for next Friday, the 13th. What time would be workable for both of you? And that's simply, it can be a phone conference, it can be at our office, whatever your preference is. It's just to discuss the issues that are pending here.
well, and he was saying that the prosecutor would need to be present,
I'm sorry,
that the prosecutor should be present.
this is a civil case. This is
I
prosecutor
know,
not
but they're
involved in this
asking
case.
questions that don't obtain to this case. So
Well, if
he's
the
asking
prosecutor
that the
wants-
prosecutor.
If the prosecutor wants to get involved, they certainly are able to do that. But at this point, this is you are
And
representing
I
yourself.
did, all this time, Aaron, when I had representation,
Hmm.
we have been answering all the questions that they've been asking.
Okay.
And we have been in line with everything. And we've been very busy with a lot of other things.
Ma'am,
This last,
There's a
we've
whole
been
list.
in the DVPO. And
I'm
that's
gonna
been-
object at this point.
Okay, let me
So-
stop you for a second, ma'am.
We have been
This-
working on
ma'am?
all of this.
The last time I did this, I had to call a deputy. I don't want to do that again. Okay? I'm setting a discovery conference. That's all I'm doing. Not making any rulings other than I'm setting a discovery conference for next Friday.
Right, without representation, I don't really understand I don't know how to navigate myself through this system. And just because I can't afford a representation, I'm trying to seek representation.
I understand that.
Thank you.
I
It's not that
understand.
I'm trying to be disrespectful or anything.
I understand. I'm simply setting a discovery conference on the 13th, which is next Friday. You could let the attorneys know that. They can let the prosecutor know that if they want to be involved, they certainly can do that. Set it up for the 13th, and what's a workable time for everybody?
I could do 8:30, I avoid 9, but 8:30, 10:30, 11:30 should all work. I can do essentially before the 9 AM docket, I can do what I anticipate would be after that.
Are there any, do you have any appointments already scheduled on the 13th,
Well,
ma'am?
that's what I'm working with Beth Fellows and also with Charlotte Rouge. So we have 2 days that we schedule appointments.
Okay, well, do you have anything scheduled next Friday on the 13th?
As of now, we don't.
Okay.
I
I'm gonna
do
set it
like
at
to
1 o'clock.
prioritize
1
that
o'clock,
first
okay.
because then she'll probably.
Okay, I'm setting it at 1 o'clock on the 13th. And you just need to have a conference. And again, you may want to talk with the lawyers, let them know you've got that set.
Right, that's what I'm seeking legal aid for.
I'm sorry?
That's what I'm waiting until they respond. He did refer me and he
Okay.
said it would take about 2 to 3 weeks.
Okay,
So
let them know.
that's why I said it wouldn't be reasonable to schedule anything until
Okay,
but
let them
I
know.
understand. Go ahead and schedule it for the 13th.
Okay, let them know you've got a conference on the 13th, and if they want to get involved, they certainly can do that.
The who?
Northwest Justice or the prosecutor, if they want, if they
There's
think there's an
nobody
issue.
available. That's why they're referring me to Waikaikum.
I
there's-
understand, ma'am. I'm setting a conference on the 13th at 1 o'clock.
Your Honor, would you be so kind as to hand out a bench order and I'll just write a bench order that's your order?
So, and you can, that'll be by phone, I assume. So. All right.
And I just asked that she say if she wants to review the order, she can. If she doesn't,
Right.
that's fine.
If you want to stick around and take a look at that order, make sure it says what I said, and then we'll come back. Well, we won't come back. Everything else scheduled right now. Okay. On the Ramos and Ramos Curiel 24-3-9408. It looks like those, we have 2 motions set for the 8th now. Is that right?
I believe so, yes.
And I think it was on for review of the guardian ad litem report.
We were hoping to have something back from Ms. Rosen, and she just hasn't had enough time to, I think, provide any input at this point.
Okay.
Your Honor.
Yes.
I'm the guardian ad litem appointed to that case. One of the things we were going to discuss today was how these the video visits were going. That's what I had us marked down to discuss today. The other bit of information I need to let you know is that I've accepted a position with the Clark County Superior Court, and so I do need to be discharged from this case. If we're able to have those matters discussed today, it would be very helpful.
Okay. The first, I'm just looking because I think there was a motion for contempt, which will be heard on the 8th, having to do with video visits.
Okay.
So that's actually not on for today based on service. And at least that's what the clerk's, the docket seems to show. The wrong case there. Be helpful if I got the right open on here. Sorry.
My report does not have information from Ms. Rosen because the children weren't seeing her at that time. So I'm not sure how that would impact a review of my report.
Right. We had come before the court to establish essentially getting that going. And then I think the court wanted to review both of those. And then they just, the Ms. Rosen hasn't been able to, I think at this point still, it took a long time to get mother to comply and get her appointment scheduled. And so my understanding is that's now been scheduled. And but that hasn't given her enough time working with the child to be able to provide anything substantive.
All right. So the guardian ad litem report that was filed July 1st, is that your final report on this one?
Correct. Yes. And then Your Honor had asked that I report on these video visits and my experience of them.
Okay. I'll go back to that. There's a lot of paperwork in, so I'm just going back to get back to the specifics. I'm just looking at the last hearing. Was that from the 8/13 hearing?
Look.
It's from
They
the
were
8,
here on the
8/6 hearing.
Yeah, they were here on the 6th and on the 13th. So I'm not sure. My guess is it would have been on the 6th because it looks like the 13th was mostly a presentation.
Yeah, that's what I'm looking at the notes. So we set it to today to review visits and the jail report. And so the other part was taken care of. So really, did you have any comments on those on the visit?
Video visits?
Yes.
Yes, we have one of the children, Solomon, who won't get out of the car to have the appointment with his father. He's very vocal about not wanting to come inside. Ms. Fellows has done a really excellent job of trying to connect with him. And I believe she at least sent notes to Ms. Baldwin. I don't know if she filed them with the court. He struggles to even make connection with Beth at all. The youngest of the two, Benjamin, does come inside. He's very excited to come in and play with the toys. Again, Ms. Fellows has done a really excellent job trying to direct him to speak with his father. Mr. Ramos does call to him, tries to talk with him. Benjamin avoids the screen. Ms. Fellows and I both observed a behavior on Benjamin's part where he will turn in profile and aim his eyes at the screen for a moment, and his eyes will sort of shake, and he then moves away from the computer. Ms. Fellows has moved all of Benjamin's toys and cars up to the table and then helped him sit at the table so that he's directly in front of the screen. We've encouraged Mr. Manuel I'm sorry, Mr. Ramos, Ms. Fellows encouraged Mr. Ramos to ask Benjamin questions about the toys or ask him what he's doing. At all. During visits, his older brother Nathan came into the room. Nathan tried to engage Benjamin. Benjamin did look up for a minute. She got down and left the table. Has become frustrated visits, but neither of the children at this point are expressing any interest in talking with him. They can't get when the visits are done with no goodbye or acknowledgement of Mr. Ramos on camera. Mr. Ramos's concern that he expressed during the visits is that Benjamin's too distracted by the toys. But even when we put the toys right in front of the screen where Mr. Ramos is, Benjamin does not look up or acknowledge his father's voice at all. And Solomon will cry. Ms. Fellows had to tell both parties that she was not willing to physically, the only way to get Solomon into the building would be if Ms. Fellows physically picked him up and moved his body into the building while he screamed and cried. Solomon does not want to come in and be a part of this. And Beth has refused, Ms. Fellows has refused to make that move, which I support. Her concern is that it would further traumatize him in a situation that he does not want to be in. So those are my observations at this point in time.
All right, anyone have any comments on that?
Yes. All of this is from a total, even though this has been, even though you ordered phone visits quite some time ago now, all of this information is from a total of 2 single visits that have occurred since that time. So we have a parent who's avoiding these visits. Children are very young. Video visits don't make sense, frankly, for children this age. Benjamin is 2. Video visits don't make any sense for a 2-year-old. 2-year-olds are not Zoom people. They are physical, tactile people. A video screen and the concept of you're going to communicate with this person that you love, this person that's your parent through a video doesn't make a lot of sense for a tactile 2-year-old. And that you see in the fact that child doesn't even acknowledge his brother. So it's not, they try to make this claim that, oh, it's this horrible event that no one witnessed except Ms. Ramos claims, but the child's treating his brother essentially exactly the same. And so this person that he essentially was living with and completely bonded with and had no issues with up until very recently, and now child won't acknowledge that person either. So this is just a visitation style that makes no sense. And that frankly, Benjamin shouldn't be engaging in. He should be engaging in regular, if we're going to do supervised visits, they should be regular in-person supervised visits for a 2-year-old. The idea that we're doing them through a video screen makes no sense at all. Again, based on the age and developmental stage of this child. The other child, Solomon, it is fully inappropriate for mother who is couched in very much trying to make her child a witness, even though he is an age where that's never going to happen or be appropriate, mother keeps him in the car, child is in the car, they drive up to the facility, he's still in the car, the child never leaves mother's zone of control. Children are not stupid. Even young children are not stupid. They are not going to bite the hand that feeds them. And that child has no other options in his world. So if mother has said, this is what you're going to do before you're going to get there, that is what that child is going to do. Because at 4, that child understands the consequences of disobedience. So mother then has that full sphere of control over the child. Child isn't going to exit the vehicle. Why would that child? And especially true if child's either suffering a consequence or receiving a benefit from doing that once they pull away. So again, huge concerns there. And especially when in similar cases, I've had judges say, why are we letting a 4-year-old control what's happening? Where is the adult in this situation? And so we have a 4-year-old now who is dictating what's happening, which is, again, not appropriate when we have a bunch of adults here. if this is sort of the standard, then every parent of a young child will just say, oh, well, Bobby Joe doesn't want to go and he cried, so he's not going to go. And I guess there's no contempt for that. That doesn't make sense. And so, again, when mother has that full sphere of control, child never has the option to engage. We never actually see whether or not this child wants to engage because child never leaves mother's sight, never leaves mother's hand, never leaves within mother's reach. Child is still fully able, child never leaves essentially slapping distance. And so that's the concern for this child is this child never has the freedom to say yes. A child is always in a position where they have to say no. So in this case, this is not reasonable. And again, even though the court has ordered clearly for visits to be happening for more than a month now, we've only had 2. And so we have a parent who's just intentionally not making these visits happen. And we've only had 2 visits. So what the court should do at this point is for Benjamin, the 2-year-old, visits should transition to a traditional in-person supervised visit so that we have a child who's allowed to engage. There should be someone else who drives and transports that child to the visit so that we have this separation. What I don't want is for children to essentially be told, this is how you shall behave up until the moment they reach the facility door, and then they enter the visit with that in mind. At least create a gap so that that child has the opportunity to say yes, instead of having one parent saying, this is how thou shalt behave, and they don't really have the freedom to do anything but that. As far as Solomon, again, I think that there should be a gap for this child, that there should be someone else transporting to the video visit. And then that child needs to continue to work with Charlotte Rosen. We have a lot of concerns about what's happened to this child and what this child has been told for the last now 7 months, that mother has essentially very much controlled this child's world. And so we really are cautious and thoughtful, especially of this child, and especially given the age of the child, very much in the realm where parents and adults can create a story. And that's where 4-year-olds live in this realm where the difference between reality and fantasy, that line is not neat and clear for a 4-year-old. And so for this child, we fully understand that, unfortunately. And that's where we're working with Ms. Rosen to be able to address that. Mother needs to be told that she has to comply with Ms. Rosen's appointments and not miss any. She's not allowed to skip them, miss them, refuse to schedule them. Because that's what we're running into now, is that the experts that the court has assigned in order to be involved in the case are being slowed when they should be working with, especially Solomon, going forward. And additionally, I want to make it clear that if Ms. Rosen wishes to work with Benjamin, she should also be allowed to do so with just unhampered access from either parent.
Your Honor, am I allowed to respond to any of that?
You can. I'm just looking for what was the order that we appointed Rosen to work on this case?
Give me a moment. That was before that. It's a different letter.
I don't recall that.
It's May 15th of 2024. Clerk's paper 74.
That's just a review order, I think.
No, May 15th. So it's a agreed order revisitation, reunification. 74. It's entered May 15th.
Oh, 74. I don't remember. I didn't order that. Someone else did. So just exactly what is Charlotte Rosen doing in this case? Because I was not part of the order in that case.
Right, so she's working with, because the concern is the length of time for especially for the 4-year-old. And so at this point, she's met with both parents and has scheduled the meeting to meet with the child once, had mother cancel that. And I believe that's now been rescheduled. Our concern is that, again, this is May. That's a long time. We're now in September. And so that's our concern, is that this has been a long time getting compliance with moving forward. So Charlotte is working to, or Ms. Rosen is working to essentially address any issues the child has and evaluate what those issues are and then remedy them.
Okay, have we had any reports from her of any kind?
No, because she hasn't been able to get compliance from mother. So if you can't
Do
meet
we
with
have a
mother or child,
proposal of what she's doing or what she's going to do from her?
other than
I don't have
reunification,
anything other than an order here that talks about her appointment.
I guess she has to be able to
I've
meet.
met with her twice already, just so that that's
Yeah.
out there.
She has to be able to meet with the child, though, to be able to make a recommendation. So she's met with both parents, but she has to meet with the child, not just take,
And she has met with the child as well,
this.
both of them, and Selena.
Okay.
And I
So-
actually brought in
so
Selena because
so
I'm the one that's
only
wanting.
one of us
to-
talk at a time.
Hold on. You're next. Let me
She makes
get
it-
my question answered, then I'm gonna listen to what you have to say. I'm just trying to understand what we're doing with Ms. Rosen's office and,
So she wants to be able to meet with Solomon specifically, because that's the child with the greatest issues. The two, so we have 6 children total that Your Honor has looked at. There's the teenagers we're not talking about today. The 2 all older, Selena and Perez. Those children already have regular visitation with their father, significant visitation with their father. So not those children. They don't have any issues. Benjamin, I would argue, the 2-year-old really doesn't have any significant issues. So it's really just Solomon that's at issue, or that has a more significant issue. So the Ms. Rosen was to meet with both parents, any of the other children that she wished to gather information, and then meet with Solomon without parents, so that then she can gain knowledge as to what the actual issues are, not just what the parents say, and then develop a plan thereafter, and then work with child and parents as to whatever that plan is. And that's what this order.
okay, I guess I'd like to see something
what
from
we're
Ms.
doing.
Rosen's office as to what exactly her approach is, what she's doing and what the expectation is, because I don't know that. I didn't enter this order and it wasn't done on a motion. It was done by counsel and a different judge. So,
Your Honor, can I respond to some of the things
you
that were
can in
said?
just a minute, Count.
All
Just
right.
a minute.
So can Your Honor tell me specifically what questions you want answered, just so I can communicate
what
that?
she's doing and why she's involved in the case.
Well, she's involved because we asked her to be.
I understand that. Well, maybe that would be helpful if I knew why that was.
Okay. And
So
then
you currently agreed to this through counsel and without the court's involvement other than approving and agreed orders. I don't know there was no motion filed, so I don't know the basis for her appointment.
right.
And
And
I'm
so as
trying to
far as,
understand that.
yeah, so as far as what she's doing, are you looking for her plan or her approach, or?
Why she's involved and what the plan is and how this is moving forward.
Okay.
All
Okay,
right,
I can
so
communicate that.
Ms. Ramos, did you have anything you'd like to add, ma'am? Did you have something? You go ahead and I want to hear from you.
I'm almost afraid to even talk. I don't know what I am eligible to talk about.
Whatever you want to tell me about what we're here reviewing these visits.
Um,
You don't have to say anything, but you sounded like you wanted to say something, and I want to give you that opportunity without being interrupted. So.
Right. This is abuse litigation. And so that's what you're kind of, there's no way to really explain all of this. It's just to cause psychological and emotional and financial devastation. So um, I'm just walking through these and I do comply with everything. And I have a doctor's note for Selena because she was the one homesick. And that's why we missed the last appointment. But we had one on the 19th, we had one on the 27th. And I don't know if you've gotten those reports from the
I
video
don't have any
visits.
reports at this point, I don't think.
So I don't really have much to, I was just letting the guardian talk, but the purpose for Solomon is to protect him from being further traumatized. And that's why I was wanting counseling, because after the criminal act, without having that being resolved just yet and being pushed in family court like this, I still wanted to protect Solomon because the state, they want to protect me and the 4 children. And so that's why I am still pursuing that, so that his psychological development is protected. And that's the whole purpose of all of this. So I'm just letting them talk about whatever that's what this hearing was for, was to talk about what they observed. And I don't want to further traumatize my children. That's my main thing. So.
Okay, thank you. And Ms. Call.
Yeah, thank you, Your Honor. The thing that Ms. Baldwin said that I agree with is that these children are not stupid. I agree with that entirely. These 2 youngest children, the reason why they avoid speaking to their father is because they allege what has been alleged and what's being dealt with in criminal court is that Solomon witnessed his father, his mother, to the point of near death. And he's afraid of his father, and he's looked me in the eye and said that. If my report had been reviewed before now, what the court would have information about is that this is an incredibly dangerous man, and that I recommended that these children have no unsupervised visitation with him. And this has been going round and round and round, and I'm baffled by the notion that somehow Ms. Ramos is coercing Solomon not to participate, but Benjamin hops out of the car and runs into the building to play with the toys, but then doesn't want to talk to his dad. I don't believe Ms. Ramos is coercing these children. In fact, Ms. Ramos has tried to schedule these visits. When the kids are sick, they can't come into the office. And like she said, she has a doctor's note. It was also alleged in Mr. Ramos's declaration that I was somehow trying to prevent these visits from being rescheduled. And it's total and utter nonsense. I've cleared out my schedule every week to try to be there for these visits and be in person. And I've observed, and I've been very clearly instructed not to intervene and to stay back. And I have done that. And I have written down notes of exactly what went on. I have observed Ms. Fellows run these visits. I have observed Mr. Ramos's attempt to interact. And I've observed these children not want anything to do with speaking with him. And to somehow say that that's Ms. Ramos's fault after everything that she's been through. We have medical records. I've read medical records going back years of abuse that Ms. Ramos suffered and that these children have been around. And I am baffled about how this case continues to go forward with some allegation that Ms. Ramos is trying to prevent her children for unknown reasons from having a relationship that is not healthy or good for these children. I'm so disappointed my report hasn't been reviewed. I'm disappointed that I now have to leave this case when I would really like to see it out. I have very serious concern and fear for these children and frankly for Nicole Ramos in this situation.
Thank you.
Briefly, Your Honor.
Sure, go ahead.
So what's challenging in these cases is we have folks who, when you look at the underlying report, it's largely based on the reports of Ms. Ramos, who obviously has her very clear position. but also on a prior ex-wife who also had filed a petition to modify. And so essentially, the bulk of information is based on these two testimonies. And one of these witnesses, who is the only witness so far to actually testify in front of you in person, we know for a fact outright perjured herself, was willing to come to court and directly lie without sort of even a blink about the conditions of her home, and said, that's not where I live. And we were able to come back and say, nope, here are the photos from a neutral observer who was able to verify, in fact, this is where she lives. And so when you have a huge amount of the underlying report based on this witness who we know A, had a motivation to not tell the truth, and B, we also know directly was dishonest with Your Honor, that starts to turn on the issues of credibility. We also know that for the vast majority of these children's lives, of these 6 children's lives, my client's been the primary parent of the 2 oldest children's lives almost their entire lives, and the primary parent of the 2 oldest children in this case for the majority of their lives. And so again, there's a lot of factors that just were not considered, or the underlying integrity of the witness testimonies was not taken into consideration. So again, in this case, there are a lot of things that have to come out at trial. But what we have right now is simply the act of moving forward appropriately with visits. And what that is for a 2-year-old, regular in-person visits make sense. For Solomon, continuing to work with Ms. Rosen makes sense. She's an expert. The parties agreed to use her for this purpose, and to create essentially a gap so that children are not being brought by mother to these visitations. So we don't have the situation where we have the one parent effectively handing off to the other. A, that creates a issue with restraining orders, but B, it also creates an issue for the children. And so it makes sense. My proposals make sense just as the practicality for the children as well as the case.
Well, the order that we're currently operating under, and I was rereading your report, Ms. Call. I'm looking at I'm looking at the recommendations that are on page, not sure exactly which page it is, but the second to the last page. And it seems to me we're doing what those recommendations are with regards to the visits. I'm looking at the July 1st.
Mm-hmm. Yes.
So I guess my question today would be are you changing that recommendation? I mean, that's the recommendation that where we got to where we're at today.
My struggle, Your Honor, is if I thought that it would have been approved, if I'm just being completely transparent with the court, I would have said that this man should have no contact with any of these children. I had no reason to believe that that would be taken into consideration. So unfortunately, right now, these are the recommendations. I regret the recommendations that I made. It was, I received things that came after the filing of this report that have only increased my fear of who Mr. Ramos is and the impact he's had on these children's lives and the impact that he will continue to have. Just to be completely transparent, Your Honor, that's where I'm at. And I know that that's a questionable thing to say in open court. The thing that I would highlight for Your Honor is that Mr. Ramos have a psychological evaluation as well as a domestic evaluation. I've requested that a couple of times, both as an interim recommendation and in this final. I feel like I'm grasping at straws to figure out how to keep these kids safe. The reason why Solomon and Benjamin are the only ones who express fear of their father at this point is because they're the only ones who have not been around him for the last several months. And we have statements from the principal at school
I'm
that
gonna
Mr. Ramos has come in and coached the children in the school. We have statements from people throughout this report that are extremely troubling.
So I do object. These are suppositions. These are guesses. These are not.
These are not guesses. They are suppositions.
They're examples
Let me
of
stop- let me
control,
stop-
his
let-
way to
let-
keep control
let-
and
let
to
me
keep
stop
the control.
Everybody, I mean, I'm working off a recommendation. That's what I have to work with.
Yeah.
I'm assuming the recommendation is your recommendation. If you're telling me that's not your actual recommendation, that's problematic. It creates.
I understand.
The court. And I understand your employment situation dictates probably a withdrawal, which means we probably have to get another guardian ad litem to probably go back through and I guess reinvestigate or supplement the investigation or something.
I support that entirely, Your Honor. And I would request that it's someone with a lot of experience and a lot of background in domestic violence. I would stay on this case if I believed I could.
Okay, but you're requesting at this point withdrawing based on your employment situation?
Yes.
Okay.
And I might offer that Keith Lawrence or Karen Lawrence would be really helpful in this particular situation. And I know that there's a process for appointing GALs, but they are very, very experienced. And Ms. Fellows is experienced as well in this particular case.
Well, Ms. Fellows is providing services, so she can't be a guardian.
Yeah, that's true.
I wouldn't have any issue with Keith Lawrence. That's fine. If Your Honor wants to reappoint someone. If you want to go by the process, that's fine too.
I don't know who's on our list right now. Who's next on that list? Yeah, who's next on the list? So she can't because she's Sherry Ewald and then Keith Lawrence.
Yeah, either of those would be fine.
Ma'am, do you have any objection to Ms. Ewald or Mr. Lawrence being appointed as substitute for Ms. Call?
I do think that it needs to be someone that is educated in domestic violence and maybe has some type of master's degree in that type of psychology. Otherwise, they won't be able to identify what's going on.
I might be speaking out of turn, but I believe Ms. Ewald does have that training and background. And I'm not sure about Mr. Lawrence's educational background, but I know he has a long history of working in those cases.
Yeah, both are competent.
Yeah, I don't have any issues with either. And I would expect they would both have the training.
So I'm fine to just take the next one on the list if we're just selecting.
Yeah, so let's go with Ms. Ewald as a replacement. So we'll appoint her. I think what I'd like to do, and Ms. Call, I'll go ahead and relieve you of your position at this time, subject to at least passing on any information you have to Ms. Ewald, so she's not starting from scratch, because that would be a waste of a lot of her time. At least she would have whatever you gathered to work from. Obviously, she's going to need to do her own investigation, but and I think what we probably should do on that basis is we're coming back on the 8th anyway. So I'll get an order appointing Ms. Ewald, and I think I'm just going to put it on for review on the 8th, and we'll get from her what she thinks she'll need as far as time before we set any dates.
Do you want me to draft that order, or is Your Honor going to draft that order?
I'll let you do that.
Okay. What do you want to do for fees? At this point, I'd probably suggest county pay. My client,
I'm fine with that.
Okay.
This juncture, given where we're at.
and I'll just put a star and it can be reviewed later.
Yeah, that'll work.
Your Honor, I believe at this point I've gone 5 to 7 hours over the allotted. Can I request payment from the county for that?
You can
Thank you.
send that to my attention, so.
I will.
I'll make sure that gets taken care of. I appreciate the work you've done in this case.
Thank you,
And
Your
then
Honor.
I'll just put in the new guardian ad litem order, the discharge of his call in the other, if that
That'll
works.
work.
For you.
That'll work, or substitute it maybe, or however you want to put that language.
Then review.
County.
Okay, that'll work.
All right, and then let's put it on for review on the 8th at 1 o'clock, and we'll discuss, I guess, the timelines for Ms. Ebald and what she's going to need. Because again, if she can get the information that Ms. Call already has, she'll be able to at least have come up to speed pretty quickly to see where she's at and what she'll need to put together any supplemental stuff she needs to do.
Do you want to put it on?
I'm
for
happy to do that, Your
presentation?
Honor.
Do you want to put it on for presentation next week? Just because I don't want to delay getting Ms. Ebald the order.
As far as, it's a pretty generic order, we're not making
Yeah.
any changes. You want to just submit that ex parte, I'll sign that.
Okay, very good. I'll still send a copy to Ms. Ramos, but if you'll just review and sign them,
Yeah,
then
it'd
it
be
won't
this-
cause a
It
delay.
should be the same order that we currently have in place, so there's really no changes to the order other than she's substituting in for Ms. Call.
Yeah, that's fine. And I can't remember if the first order was county pay or not, but I think at this point that makes sense.
I don't recall.
It was
should
it was
be.
50-50. We had 50% county pay and 50% Mr. Ramos.
I think at this juncture, I'm going to do it all county pay since we're going into a secondary layer. So.
Okay.
All right, so that's what we'll do today. I'm not going to make a change in the order today. And again, it's based on the current recommendations and then go from there. So we'll be back on the 8th at 1.
All right, very good.
Thank you, Your Honor.
All right, thank you. That's all
Thank
today.
you.
Okay, go ahead.
The Ramos and Ramos matter, this is number 5, 6, and 7 on your docket. This is 24-3-000-9408. We have the Mrs. Evald, who's our current guardian ad litem. Usually Miss Ramos appears in person. I don't know if she's there.
Do I have, oh, there you are. Why don't you come on up to a microphone? I do have Nicole, are you Nicole?
Yes, Your Honor.
Nicole Ramos is present. And I think your client, Ms. Baldwin, is online
He might be.
or was.
This case is actually assigned to Judge Basher, and so since it's assigned, it really should be set over to next week.
Yeah, I saw that and I did very little review on it, assuming that that would be the case. So Ms. Ramos, Judge Basher had to be gone today, so I am filling in, but it is pre-assigned to him, so I would like to get it back on his docket. We could do it as making sure there's room. We could do it as early as next week or any other Tuesday at 1.
Actually, I'm working with Northwest Justice,
Okay.
and he's referring me to get some representation. And so he did say that it could take a few weeks. So I was hoping to maybe just go ahead and continue it out to the 29th and keep it on Judge Basher's.
These are my motions. They are timely filed and we have waited for these dates. Some of them are regarding property that my client needs in order to be able to work. And so we're asking just to set over 1 week.
So Nicole, what I'm gonna do this, Ms. Ramos, what I'm gonna do, I will just have you come back in 1 week and Judge Basher can handle any further motions you may have if you do have a lawyer, since it is pre-assigned to him. So a lengthier continuance like that should be handled by him. You can log in via Zoom next week, so you don't have to physically come in person. It's up to you, okay? So I'm just gonna set Ms. Baldwin's 3 matters. That's the review hearing, her two. We have a review hearing first, then we have a motion hearing for property transfer and the show cause contempt. Those are the 3 things that you'll do next week. Okay? Right. Okay. So I'll set this over with associated bench copies and orders to Judge Basher to October 15th at 1 o'clock.
Your Honor, can I ask a clarifying question really quickly?
Let me get, I have to open up my Zoom. Is that Ms. Call?
It
Yes,
is.
go ahead.
I'm just, so I was recently brought on as the Family Court Services Coordinator in
right.
Clark. Yeah, and that's one of the reasons I asked to be discharged from this case. So my question is, I just need some clarity about what we're reviewing and if my presence is necessary or if Miss Ewald is able to take that on going forward.
So my understanding is that the court discharged you when we entered the new order appointing Ms. Ewald. I believe that's included on the new GAL order. And the court was reviewing, essentially asking her for her timeline on how long he expects. We set a date for her to have a report, but it was just sort of a placeholder until she could give the court more input.
Okay, that's what I was looking for. Thank you.
Yep, and I can double check that order too, see if we need to change anything, but it does add her.
Part of the issue I'm experiencing is I
And
can't
it is-
access the Cowlitz documents anymore, so I couldn't look for
Right.
clarification.
Yep, you are discharged formally in that order as number 12.
All right.
Thank you for being here. Congratulations on your new position.
Thank you. Thank you. I appreciate that. I will miss Cowlitz County though. Thank you, Your Honor.
Thank you.
Thank you.
Okay.
This matter 24-3-9408.
That's ready. And would Your Honor mind turning on the courtroom camera? That one has gotten
it's not.
switched for the witness stand. Thank you.
We'll get that on. There we go.
Thank you.
Okay. Let's see. Ms. Ramos is present in the courtroom. I believe I saw Mr. Ramos on Zoom.
He is.
Okay. So just two things. We've got about a half an hour left. Hopefully that'll be sufficient to get through this. It appears to me there's three things before the court today.
I'll say 3.5, and I'm gonna actually hopefully take one away, or take 2 away, actually. So we should be in a good position time-wise.
Okay.
And Your Honor, Sherry Ewald Jail, and I will want some clarification on your order. So if we have a minute for that, if that's not on Chelsea's list.
Which order?
I think the guardian ad litem order. So that's my half.
Okay.
We'd also had, we were set yet last week, and then we had to put it over for Your Honor, since this is assigned. We had put in a reservation into the guardian ad litem order when we entered it, because we had put in dates for the guardian ad litem's report, but those were sort of just tentative, like placeholder dates. And so you wanted to actually talk to the guardian ad litem to see if those dates actually worked or were realistic, given sort of the complexity and amount that this case is. And so I know that you wanted to check in with her as part of today's hearing as well.
Okay, let's do that first. So that would have been the order we entered on the 19th.
Yes.
So where I'm at, Your Honor, is I've gotten the intake back from Mr. Ramos. I've had some text communication from Miss Ramos. I do not have her intake packet yet. I have made contact with Charlotte Rosen and have received an update from her as to where we stand on visitation. I think there's some question on where that's supposed to go right now. I do know that Ms. Bellows was supposed to do some supervised video visits, and I believe she heard from Ms. Ramos this morning or earlier today, and they're trying to schedule that now, but there haven't been any of those. So I'm really at a standstill until I get the information from Ms. Ramos, and until those appointments get scheduled so we can work on those. And then the clarification I wanted, just so I can say, is that you had a full report filed by Miss Kale, Heather Kale, on the past GL on this. I don't know if you want me to start over. I don't know if you want me to dive in there somewhere. So if you could just give me some direction, and I will get that for you.
Sure. This is a very unusual case. It's very complex. And the prior guardian did a great deal of work on it. So what I would suggest doing is if you can review whatever information she provided to you, and then I guess I would go from there. That report is that report. So you kind of be working from there. I think she did a lot of work, and I don't know how much of that information she relayed onto you, but I guess you would need to give us a final report or any other reports you think are appropriate. I think we've got it set, looks like January 21st, 2025. And if you do not believe that's sufficient time, then if you can let us know that, we can adjust around on that. But if you haven't had enough, have you got any information from the prior guardian?
Did make her file accessible to me. I didn't want to look at it until I had direction from you.
Okay. Yeah, it doesn't make sense for you to completely duplicate all the work, but I think there may be portions of it you may want to do your own looking at. Some of it you can rely on records, obviously, that type of thing. So maybe what we need to do is have you do that, and then I can, if you want, we could either have a review on a deadline issue if you don't think you're going to have enough time. Or we could just leave it and let you bring it back before the court if you think you need more time.
And then I'll bring it back before the court if I need more time, and hopefully read from Ms. Ramos soon.
Okay, and Ms. Ramos, you will need to make sure you get a hold of the new guardian so she can get updates on everything that's going on from you so she can move forward. Okay. Okay. Any other questions on the GAL report?
The only other thing I'd say is I hope that maybe one of the parties is going to address clarification on either the supervised video visits or the Charlotte Rosen visits, because obviously I need to watch those and see those and participate in those. And if those are going to be delayed for a while, then again, our date's going to get moved. So I would just hope that we could get some clarification on that today.
And I'm going to address that.
Okay. All right. So let's go ahead with you said there were one of these may disappear or?
Yes, well, I'll say half. So we have on a compel, a contempt, and an issue regarding property. So on the contempt, what I'd like to do is set that over. As far as I know, I didn't receive any response from Ms. Ramos. It's regarding the phone calls or the video visits that are supposed to be occurring with Ms. Fellows. And really the question that this turns on is the child refusing, or is the mother sort of making the child refuse? And the best evidence to answer that question is really Ms. Rosen and her reports. And so my proposal would be to set this out 3 weeks and to allow Ms. Rosen to sort of complete at least her initial investigation, or her initial, I shouldn't say investigation, but her initial meetings with the child, but with the caveat both in as to Ms. Rosen and as to Ms. Fellows, that when either of them set the appointments, no one's allowed to decline them. No one's allowed to not do them, to say, no, thank you, I just don't want to do them. Because we've had a lot of issues and a lot of delays. The order for Ms. Rosen was entered significant number of months ago. The order for phone visits was entered more recently. And we have these huge gaps where we have people just saying, I'm not gonna do that. And so I think it would be helpful if Your Honor just said, hey, if those providers make a date, everybody's going to make that date. And then we'll have updates from those providers that I think would provide clarity for everyone, one way or the other, on whether the child's refusing or whether or not the mother's essentially requiring the child to refuse.
Ms. Ramos, is that workable for you?
Just keep in mind that I am a stay-at-home parent for 5 children. And sometimes there are, like the last one, like Miss Heather Cal brought up, she's trying to hold me contempt, but my child was sick, so we missed the appointment. It's not that anybody's saying that they don't want to go. And then those prior ones for the weekly visiting, the video ones, we had ordered to do 4 weeks beginning the 19th. And so I did schedule that first one with Beth the 19th, and then we did another one the 27th, which we have that report here. And then the children were sick, so obviously we missed some appointments. And I have 5 children, 2 of them got sick. The Solomon was throwing up, that's why I have the pictures, just to show documentation. And then I have Selena's doctor's note, like Miss Heather Kell also said, that I do have documentation that shows that it's not that I'm like not
Okay.
complying. And then we do have another visit scheduled. We just had visits with Charlotte. There's 2 visits going every week. And keep in mind, I'm taking care of 5 children. So there's 2 weekly visits that are an hour long. One's gonna be the video visits, one's with Charlotte Rosen.
Mhm.
And then we also have, soccer, we have church, we have school.
Okay.
So Solomon's in school till 4. And sometimes their schedules don't allow the same availability, so there's possibility that a week will lapse just because their schedule doesn't work with ours. And that's not that we're not complying. That's where I'm kind of confused that
Well,
it's
here's,
being turned like
here's
that
what I,
I'm
here's what I need to have you do.
contempt.
Okay, if the providers come up with an appointment and it all works for everybody, that needs to supersede soccer or
Right.
even school. If that's what I suspect they're not going to set an appointment during school. That's unlikely, but they could. If your child is sick and goes to the doctor, that's obviously going to be a reason why, and we're going to have documentation why it didn't happen. I suspect that the providers don't want to have a kid thrown up in their visitation room. So the question I have is, are you willing to do the appointments as they're scheduled to the best of your ability?
That's what I've been doing.
Okay. Okay. So that's, and I think if we set it out 3 weeks, we'll have a better picture of where we're at.
So Ms. Rosen specifically asked the court, and I'd asked the court to do a bench order so there's no delay, that just says essentially what you said, that if Ms. Rosen sets an appointment or Ms. Fellows sets an appointment, that overrides everything else. That mother can't set a dentist appointment and then say, oh, well, there's a dentist appointment now, and sort of use that to sort of undermine or
If
those
I
types
have
of-
documentation of the dentist appointment already previously scheduled,
Just let them know that.
that wouldn't be me just coming up with a dentist appointment.
You just need to let them.
So I have to show that documentation each time that I'm telling the truth that I did have a
No,
dentist
let-
appointment scheduled,
Let
that
Miss-
it did interfere with
let Miss Rosen know, and she won't make an appointment when you've got a dentist appointment.
that's what I've been doing.
Okay. And that's not gonna be an issue.
Your Honor, is
Yes.
there a way that we could do 1 visit per week for scheduling? It's kind of difficult to accommodate 2 days a week, 1 for the video visits and 1 for the reunification, especially with Solomon being in school.
I'm not.
Solomon is not school aged.
I'm not.
He's in
changing the order
preschool, which is good.
Indicating appointments with Rosen or Fellows are to have priority over any other appointment or activity. And the parties are to make their best efforts to attend. And then if we could just make sure that Ms. Rosen, I assume if Ms. Rosen knows that you've got a dentist appointment scheduled in 3 weeks or in 2 weeks, that she will not set an appointment at that time. And then if something comes up where the child needs to go in to see somebody for whatever reason, again, absent they get hit by a car and they gotta go to the emergency room, that's obviously a different situation. But if we're setting up an appointment, you'll know when those appointments are and you just need to schedule around them. So, and let Miss Rosen know and Miss Fellows know what your regularly scheduled things are, and they'll try and work around that. They're not in a goal to try and make this difficult. They want it to work for everybody. So that is the order I will sign today.
Very good. And let me know when you're ready for the next issue.
Give me just a second here. I want to make sure I. And then we'll set that motion over 3 weeks to the 5th.
Yes,
Okay, and then we'll take a look at that and see how things are going.
very good. So the next issue should be very brief. There was a motion regarding property.
One second,
Oh,
my
sorry.
clerk's asking me a question. That's the contempt letter, yes. Okay, go ahead.
So the next issue is should be very brief. Again, regarding a transfer of property. My client had a list of 10, 15 items, really specific, really narrow, and no response received. To my knowledge, there's no response filed by Ms. Ramos. Sort of late in the 11th hour last week, she did drop off a number of items at my office. That was great. We appreciated that. We were able to inventory those. There's only 2 items that remain, and those are soccer team benches and like a team ball bags of balls. So it's like a whole bag full of soccer balls. Since my client is a coach, we're just asking that those be delivered within the next week. Those are the only 2 items that remain missing.
Your Honor, I did deliver the bag of balls that were in the garage and the items that they were asking for. Also, I did reply to them, and I also have the emails that I was trying to reply to Miss Chelsea, and I said, you can read this. And this was on September 10th. And I said, I have no issues with exchanging the requested property as we can agree to.
I'm
Also
not,
exchange
so my
property.
concern here, so I'm going to object.
Excuse
She
me.
wants to get into settlement
Um,
negotiations that she
Hold on
made.
hold on just a second.
Because I was speaking
just-
with Northwest Justice, during this process, because I didn't really know the process or what I do. And he said, do email her and communicate with her. So that's
Right.
what I was doing. I wasn't filing any motions or things with the court or respondings. And he did say, that to make sure to let you know that I did offer to give those things back. And I work to facilitate a safe transfer. And I was just asking that he said a lot of times that it's common to ask for when it's your belongings too. It's a property exchange. So I do have a vehicle that's in my name and it's repossessed through the credit union. And so it's reporting on my credit. And I was just
Same
asking
objection.
for that item back so that they could repossess it.
Same objection, Your Honor.
And I have that right here as well.
Okay, hold on just a second, ma'am. Just let me stop.
So
you.
I was just asking for that in return.
Ma'am, let me stop you for just a second, please. I'll be happy to hear whatever you have to say, but let me stop you I'm focusing on one thing. It made a request for a bunch of property. It sounds like you already taken most of that over. And you're telling me you took the bag of soccer balls?
Right. Everything that's listed, I brought to the office.
What about the soccer benches?
There's not any to my knowledge. If he could be more precise on like where it would be, maybe he's thinking that it was in a certain area and it's actually in like one of his garages or shops or somewhere else. I'm not exactly sure. But if
Okay.
it's just a bench, I did give all the tarp coverings, all the pop-up tents, everything that was anything that looked like that. So there's not anything else to give. And then
So it sounds like
I gave all the soccer balls that we have, so.
Okay. So it sounds like she's given what she has and apparently.
And I can provide it's not a bench that's sitting out. It's a bench that collapses. So I can.
Right, and it would be in a bag or like kind of like a tent.
For her.
It would probably look like a fold-up tent.
Right, and there's nothing like that.
It doesn't look like a folded tent.
But the garage is only so big, and I know that there's nothing like that in our garage or in our house, so I'm not sure where it would be. Sorry.
that issue-
And I would love to comply.
How about if you can get a little more specificity, color, size, where it might be,
Sure.
and exchange that via email? I'll take a look at that when we come back on the 5th as well.
Very good. So that takes us to the remaining issue, which is the motion to compel.
Okay.
If you read the motion to
Let
compel.
me stop you for just 1 second. And this is not a motion properly before the court, but I just want to simply ask a question. There's apparently a Visa card, you say, that's in your name only?
Oh, no, it's a vehicle.
A vehicle?
Yes,
You've
and
already
it's been
ruled on that.
repossessed. It's in collections and the credit union is telling me
Okay.
that I'm withholding it from them and I'm not. It's just that he has it in his garage in a
Okay.
shop. And I was just asking that since we were exchanging properties, that was great that we were communicating that. And I
Okay.
wanted to give him his ladders and his things, but I just wanted that
I'm going to
car
object.
that they
Okay.
can collect
Okay.
it and repossess it.
Same problem.
I'm sorry?
So I'm just lodging my address. The same problem is that there's settlement negotiations and then the vehicle you've already ruled on actually. So that's already in a prior order.
That's not a vehicle that he ruled on. You just put that in a document. That was never a vehicle that was mine or to be in a ruling. That's a vehicle that is owned by Tapco Credit Union and they want it back.
Okay. And again, that issue isn't in front of me at the moment. I thought it was a Visa card. I
No.
misunderstood that. If there's something like that, file a motion. I'll be happy to hear it.
Right, which you have to file a motion to get that property back. That's why I was hoping we could just negotiate like she was wanting to do.
You're free to do that, but not in the courtroom.
Right. Thank you.
Okay. So,
And then keep in mind that the reason he's not paying child support.
So
And I'm just on
again, this
TANF.
isn't a free for all.
I'm on
I guess I
TANF
have an
for
issue with.
$700.
okay.
And so he was saying that he can't pay that.
So
Okay.
again,
And I don't
So-
have an attorney to file like
I understand.
motions on that
If you
stuff.
believe there's a reason to come back to court on any issue like that, then you can file a motion. You don't need an attorney to do that.
Okay.
You can come here any Monday. There are attorneys in the lobby who can give you some assistance in how to do different things like that. Make a list of the concerns, bring it over, and they'll have somebody talk to you and walk you through it.
Right, that's what I'm actually working with, Northwest Justice and I've spoke
Okay.
with Joyanne, so it's just a process. She said in 2 weeks that, things should be moved along and
Okay.
we'll be able to
So
get.
file a motion, you'll be happy to look at it.
Because none of those clinics can help me. I've been to them, those legal help aids.
Okay.
so if we can address the final motion.
Okay. So that's the motion to compel.
Yes. So the final motion is the motion to compel. If you read through the motion to compel, a substantial effort was made to gain the respondent's compliance. Letter after letter, email after email. I had to motion to get a CR26I, just non-compliance, absolute refusal to provide basic documents, basic items. These are not complicated things. These are things like wage stubs, very, very simple items. And again, substantial effort made to get her to comply, and she provides nothing. I provided hard letters. Here's the list of things you haven't provided. She doesn't provide. We do our 26I. We agree on a date. She doesn't provide. Eventually, she just sends me back a list of I send her an extra copy of things, the requests, and what I get back is just objection, objection, objection. I'm just not going to answer. And again, that's not appropriate. There's nothing other than just a bold-faced objection. There's no basis to the objection. And again, these are really simple requests by and large. This has taken us an inordinate amount of time because I had to motion the court just to get a 26I. The court then set that out to 2 weeks just to do the 26I with her. We did the 26I. I gave her extra time. I gave her extra time after that, then file the motion. That's 3 more weeks. So here we are, months and months down the road, just trying to get basic discovery. And the objections are baseless. It's just, I'm not going to do it. I'm not going to provide it. And these are basic things I need to be able to proceed in the case. So you're asking the court for an order to compel. I'm asking for $1,575 in fees. That represents 3 hours of my time. That is far less than what this has taken my client to get to this point. and more than reasonable given the substantial efforts. And I'll just say, she's not my client. It is not my job to handhold her through this process. And nonetheless, that's what I've done, trying to gain compliance and avoid having to file this motion. So after all of that effort, we're still in a place where I don't have those basic items that I requested. So I am asking the court for the order, I'm asking the court for the fees, and I'm asking to review this November 5th.
Yeah.
As you recall, I did have an attorney up until July,
I do.
and she was working, she did reply to the discoveries as they were requested, and then after that is when we started together taking care of the discoveries. And then I was seeking legal counsel because there was a lot of questions that were conflicting, especially with the criminal case. The prosecutor had said, you know, those are things that he would need to be present or have, you know, they're asking for my social media information and a lot of different documentations that don't pertain to the parenting plan or to this family law. And it's the person from Northwest Justice had said that he feels it's more like of a backdoor discovery to try to gain information through this family court to help for the criminal case. And so he had said to object to a lot of those things that because and so next, when I do get the attorney, we will comply to whatever is necessary, but
when do you expect to have an attorney on board?
She said 2 weeks. She said I should hear back in a week. And then by 2 weeks, I was speaking with Joy Ann today with the contract attorneys because Northwest has referred me to Wacayacum. They didn't have anyone available. And so they also referred me now to the contract. So I've just been seeking every avenue that I can for any type of assistance. And this is only, you know, if you think about the domino effect, this is just, I was a stay-at-home mom for years. And then there was, you know, the criminal charges of the assault too and the reckless endangerment of a minor child, which that brought the domino effect of what's happening now. So he filed for divorce and he's filing all these things on me, knowing that I don't have financial stability, knowing that I'm a stay-at-home parent and that my day and my life is just, that's what it's been. And so this is, I'm doing my best to try to keep up with all of it. And so I've sought many legal, you know, because I don't have the financial stability. And I'm just on TANF. That's why I'm not sure why they're asking for pay stubs when I'm on TANF and I have it right here. You can have this copy.
So let me stop you for just a second.
So it's not that I'm an objector or not giving information. We've given a lot of this stuff.
Okay, so.
And I feel she's coming very aggressively and just demanding and just, you know.
Okay. If you have an interrogatory that says provide your pay stubs and your source of income is TANF,
Right,
that would be.
which that's been provided.
Okay, if that was provided, then that's fine. I don't know what all each of these is. I've just got a list of things. But there are very few objections to discovery that are going to be they're going to hold up. It doesn't have to necessarily be specific to this case, because if it can lead to information about this case. So it's a very loose definition under the discovery rules. So a couple of things, and I'm just trying, I can't give you legal advice. I'm not allowed to do that. I'm trying to give you some guidance here. If you simply say, I'm not going to answer a question, if you do that, then the end result of that typically is if there's at a trial questions about that, you wouldn't be able to testify about it because you haven't answered the question here. So it's kind of a domino effect, like you're saying. So this case it's related to the criminal case, but it's not really related to the criminal case.
So for example.
Let me finish. Let me just listen, okay?
Mm.
If the prosecutor's telling you something, then they probably need to come and show up here and tell us why they think this shouldn't work. And you're going to get an attorney it sounds like in a couple of weeks. So what I'm going to do and it's not gonna make Ms. Baldwin happy. I'm gonna set this out 3 weeks. Okay, I'm gonna reserve on the fee issue because I want you to get your attorney and come in and respond to this. Okay? I'll give you 3 weeks. I would go through everything in her motion and look at the information that you've gotten, the requests, and anything you can answer, you should do that.
Okay, even if it's reduplicating,
Even if it's what?
reduplicating.
Even if it's.
Because Miss Erin Winkles, as far as I know, they provided, that was the first part of this
Okay.
discovery.
Mhm.
And I hadn't heard anything back from it until August.
Well-
And that's after I didn't have an attorney and then
You may
started
wanna
kind of a,
check with Ms. Winkles, because if she's got some of the answers to these, then maybe you can just get those and provide those as well.
okay, and that's
So
something
Ms.
that,
Winkles did answer, a number of their answers say, will supplement, we'll provide this later, is attached,
Okay.
and there's nothing attached. So the letters that begin in July specifically outline what's missing when they said it's attached and it wasn't, when they said they'd supplement and they didn't. So the letters and the emails go through point by point by point and lay out what is missing.
So if you look at the motion, this was the one that was, let's see the date on it. Was September 24th.
Right.
Okay, take a look at that and go, those are the things that she says are missing.
okay,
If
those
you-
are the main things to focus on.
That's
is
where you
what's
want to
in-
focus. Yeah,
okay.
just the ones that are missing. If you've already answered some questions, she's not asking
Well,
for that.
some
I
of them,
wouldn't
it's
worry
not
about it.
possible for me to supply, like she's wanting detailed cell phone records, which show incoming, outgoing calls, voicemails, and texts between you and Chantel Shirley from January 1st of 2023 to the current date. Then she wants all social media conversations with Chantel Shirley from January to the current date. They want all messaging app conversations. They want detailed cell phone records, which I don't have access to because my phone was in his name. So I don't even have access to those records. All social
Okay,
media
well,
conversations with
then-
Chantel Zimmerman, my sister, my twin sister.
If-
And they want all messaging app conversations with my twin sister. How is that
So
relevant to
here-
this? So that's overly burdensome.
if there's information that you don't have access to, that's your answer.
Okay, so, okay.
But if you have access to it, then you need to make the efforts to locate them.
And then some stuff is invading privacy.
There's an awful lot of things
So
that happen
then-
in lawsuits that tend to dig a lot deeper than you may want. And again, there's a lot of things that come out in discovery. This is not a public record case, so there's the discovery information does not get published someplace. So it's not a public document, but they still are required to be answered. Okay. All right, so I'm gonna set it out 3 weeks.
So I'm gonna
And
ask for one caveat though, is that it be heard, because this same line of, I'm gonna get a lawyer, since your honor's been assigned, this has been the
No,
same line
it's-
the whole
I
time.
need an answer on the 5th. And if your lawyer's getting involved, they need to understand that.
Right. Like I said, I've just been seeking every
I know, I
avenue
understand.
for people that can't afford attorneys.
Mhm.
And
And
so
it's-
these are,
yeah.
that's just the steps and how long it's been taking. And
Yeah.
unfortunately, I don't have a right to an attorney, even though I'm a victim of assault and abuse in this criminal case. In the family court, it doesn't matter.
I understand the challenges in finding a lawyer. I am
Right.
definitely aware of that. I think Ms. Baldwin's aware of that. It's not easy to find a lawyer.
Right, but we're making progress.
Good.
So
Good.
that's what I was told. Joy Ann said that, I just spoke with her this morning, so.
Okay.
I am hoping that it's just a week, but like she said, could be 2
Well,
weeks.
if they're getting
so-
involved, make sure that they show up on the 5th.
Right,
Okay?
that's the next step is,
Okay. 1 o'clock on the 5th of November. Continued motion. I think that's everything on this case today.
Yes, your honor.
All right. So we will adjourn for the day. Ramos matters.
That's it.
And I've got 2 cases on. If I can have you have a seat at the counter, ma'am. Just for simplicity's sake, the one of the cases, the 24-29608. This is on for review today. I believe this is set on for review to get some feedback on the video.
We're just checking on what the criminal case was. And so, because we were kind of waiting for the criminal case to complete so we can get access to the CJAC video. Unfortunately, in the criminal case, the prosecutor's office, the assigned counsels changed several times in the prosecutor's office. And I believe at the last hearing that their office was asking for a continuance. Just because of those changes. And so I think that case got set out because of that. My proposal would be to just to set a review out into probably January, I think is a reasonable time frame, at least to review it.
I did want to advise, I somewhat belatedly got the video information. I don't know who's going to review it, but one of the other judges is going to review that to determine admissibility. So that would not have been ready to go today anyway. It looks like I probably will need to get another to reissue the order that we issued July 26th.
That's fine.
And re-extend that. Does that work for you, ma'am?
It's re-extending
The no
appeal.
contact order that under the protection order.
Right.
So I'd be extending that to our next review hearing. January probably is reasonable time-wise.
I'd ask for not the 7th, but after that, I'm fine.
How about the 14th?
14th is
Does that
fine.
work? That would be for review of the protection order status.
Okay.
I'm inclined to leave. Is there a problem leaving it on this docket? Or any problem leaving the protection order on this docket for reviews? Okay. That's just simpler than on the other docket. So we'll put that on the 14th, which is a Tuesday at 1.
Sorry to interrupt. Can I just ask for a pen? May I use a pen, please?
Do we have something she can write it? You have some paper down there, ma'am?
I do. I just.
Okay. You have a pencil down there? Yeah, so, and that'd be at 1 p.m. I'll just do another reissuance of that based on the one we have.
That's fine, so long as it matches the.
It'll be I'm just gonna photocopy this, change the dates on it.
Very good, that works.
That was number 73, so I will do that right after this doc. So, all right, so that's the first one. Now, the second one I've got, it's shown it's on for two things. One was the Ms. Ramos's motion on abusive litigation, and the other is on for review. And I'm going to ask for some guidance on that, but I think we just set that over to review the property transfer.
We sent it over to review the property transfer, and I think we also, we're just confirming with the guardian ad litem on her. I think we mostly managed the guardian ad litem's timeframes last hearing. On the property transfer, I did email the respondent what was missing. I haven't heard back from her on the items that were missing. They're not insubstantial. I mean, it's several $100s worth of property. And so my client would ask that she make that effort. So that's where we stand on that. So I mean, I'm willing to give her additional time to respond, but.
Can I just respond verbally right now? It's about those missing soccer balls and the bench. And actually yesterday I found out from Selena what happened. So the bag had balls in it when I returned it to them. And I was asking Selena, I said, were there more soccer balls around? And she said, well, probably when we were playing with them, because we live on a hill. So I wasn't aware that they were playing with the soccer balls, but she just told me yesterday that when they've been playing with them, sometimes they go down the hill, and we live up on West Linwood Drive. Once the ball goes down, it's gone. So I'm assuming that they kept taking, and there was probably, I don't remember there ever being like 12 soccer balls, because he always kept his bag of the balls that he used for soccer in his truck. And in the back of his Tundra, he always kept those things back there. So everything that was in the garage that was related to soccer paraphernalia, I did return, so there really isn't anything else to return, unfortunately. And I don't have any more soccer balls to return.
Was that the only items that were missing?
So
Or
it was I mean, it's unfortunate because they were, my client indicates these are essentially brand new and it's an entire bag. So we're talking about $250, $300 worth of soccer balls that the claim is that the children essentially just kicks them down the street. The other item was, it's a collapsible bench, and I sent her pictures of like examples of like, this is what it would look like. Because people can have different ideas of what's in their mind's eye of what that means. And so I did provide a couple different examples, saying it might not be this color, but these are some examples of that. So
and did you see that anyplace?
I
ma'am?
did, I looked for that item in the garage and all over the house, so I'm not sure if he stored it somewhere else and doesn't recall where he was keeping those items, but they're not on our property.
Okay.
He does have many other, like, he has his garage that he keeps a lot of his supplies in. He has different places because of the business.
Okay.
So maybe he just doesn't remember where he was keeping them, I'm not sure. I've given back everything and more. I've given back everything that is, like, I went through the clothes and everything and I brought them to her office just to avoid any more, you know.
Okay. So I don't know what you want to do with that. I mean, it sounds like she's returned what she has or what
right,
she
I mean,
can
at this
find.
point,
so.
or what she's willing to. So at this point, it'll just be an issue for the dissolution.
Okay. All right, so that, we'll assume that's resolved at this point, other than any future claims on that. If you do find any of that, that
Oh, of course.
needs to be
I'll bring
returned.
it right through.
And then, excuse me, I apologize.
That's why I made 3 trips and brought things to her office Friday.
Okay. And then on October 1st, you'd filed a motion to restrict litigation. And so I have reviewed that. And did you get Ms. Baldwin's response to that?
Yeah, I
Yes.
filed a response.
Or did you get that?
Yes, Your Honor.
Okay. So I didn't see anything, and you didn't file anything additional on that.
Well, I'm in the process with attorney contract, because Northwest Justice had referred me a few times into Wakaikam. They didn't have any legal representation for me. So now I'm with Joy Ann with contract service attorney services through Northwest Justice Project. So I am hopefully receiving, you know, some type of
Okay, are you planning
representation.
on filing a response to the reply?
I was just wanting to verbally discuss with you.
I would object.
Hmm?
I'd object. She can make
That's part of
arguments.
abuse litigation.
Well-
Overwhelming. I don't have the time to be in here in court. I have 5
Okay,
children.
all right, no, I understand. So there's a couple of options. This is your motion. So if you want to proceed on it, then what's in the file is what I can proceed on. If you want to reschedule it, you certainly could do
I
that.
just wanted to address the issue that this is abuse litigation.
Okay. Well, I mean, you filed your motion and she's filed a response, and then so it's this argument on whether or not it qualifies or not.
Right. And that's what I thought we were here for.
Okay, so go ahead.
Okay, so on February 2nd, 2024, I just wanted to bring to mind why we are here for the domestic violence that is pending, the criminal case that keeps getting, you know, a new prosecutor, and we're following that with the protection order. And they also put a no contact order after the event. The state put the no contact order, not me. I never even called the police on him. I've just been battered and been beaten for over a decade. So, and I have so much paper trail history, documentation, and medical records to support this. And I've been working with the emergency support shelter after this event when they removed him from our home.
Right.
And that was because of the assault, 2nd-degree domestic violence. So he did intentionally assault Nicole Ramos, thereby recklessly inflicting substantially bodily harm on Nicole Ramos, and did assault Nicole Ramos by strangulation, contrary to RCW and against the peace and dignity of state of Washington. And they further do accuse the defendant, Jose Manuel, at the said time committing the above crime against the intimate partner, a crime of domestic violence within the meanings of RCW 1099, and further do allege the crime involves following aggravated factors and accuse the defendant, Jose, of committing said offense involving domestic violence within sight or sound of the victims or the defendant's minor child under the age of 18. And then the second count is reckless endangerment, domestic violence, because this domestic violence has been progressing. And I think it's because of his drug use that he's, but that's aside another story. So his second count is reckless endangerment. That was because on February 2nd, he did recklessly engage in conduct which did create substantial risk of death and serious physical injury to another person by assaulting Nicole Ramos, myself, while she held her minor child, Solomon. This is why I've been so adamant on protecting my child, because I've seen the abuse and it's progressed so much that it's an endangerment to my children even. So that's what brought us here. And the state did put a no contact order for me and the 4 children to protect us. So I was confiding in our system that they would protect me through this. Now, abuse litigation is when, and courts don't really know all of this. It's not very common, or it can be, but it's not identified. But the term abuse litigation includes the misuse of court proceedings by abusers to control, harass, intimidate, coerce, and impoverish survivors. Although the practice is common, it does not have a general recognized name. It has also been described as legal bullying, stalking through the courts, paper abuse, similar terms. Court proceedings can provide a means for the abuser to exert and reestablish power and control over the domestic violence survivor long after the relationship has ended. The legal system that the survivor believed would provide protection becomes another weapon that the abuser can use and cause psychological, emotional, and financial devastation. This is
Let me stop you for one.
Appendix H.
Let me stop you for 1
It's
second.
important.
What you're doing, you're essentially reviewing the document that you filed, and I read that. And I know what the topic is. I understand the topic.
Right,
So the question for today is whether or not
right. I'm
That's
giving you an
happening.
outline of what I'm going through. The process.
Okay.
This is because I'm just a survivor of domestic violence. And I'm thankful. I'm blessed to be alive. God, kept me alive through all of this. And, I could be on the statistics, which is, I brought that. The statistic rate is rising in domestic violence and deaths. There's 49%, and I was gonna be on that statistic of death, but the Lord kept me alive. And I'm here, and I even lost my voice. I have records of that right here from the off. And you've seen that as well. That I lost my voice because of the strangulation. I almost lost my vocals and wouldn't have been able to speak today in court. My life was at its last breath.
Okay, can you focus on the motion that you requested specifically?
Right, which is abuse litigation. That's the process. The court doesn't seem to understand that that's being used as a weapon that the abuser can use. That's what domestic violence is.
No, I understand it can be used as an abuse. It's whether or not it's being used
Right,
here.
whether or not you're gonna protect me through it is your decision. That's,
I don't know what to do, and here's the problem. First, I have no control over the criminal case. That is what it is.
right,
You filed a protection order, which is, we're processing that through. He filed for dissolution, which is perfectly appropriate under the circumstances. So I'm not understanding what you're wanting me to do. The cases that are all pending are all appropriate cases to be pending. So I guess I am not understanding what you want me to do.
to just follow the criminal case because that's why we're here. And to restrict some of the litigations in court, especially if I don't have any representation. This is causing a lot of emotional and financial hardship on me and my family and for my healing and surviving. You know, I got a job so quickly at the credit union, but now I'm not working because of these courts, the court hearings.
Mhm.
And if you
I'm
look
gonna
at my
object.
social security
None of that's
statement,
for materials.
it gives you a clear view.
Okay. Okay, but what
I
I'm,
graduated in 2005. Would you like to look at this?
what
So that you
that's
can
not
see
been,
it.
oh, hold on. I've got what you filed.
This is domestic violence.
I'm asking you what you're asking me to do.
To limit the process in the family court system so that I'm not continually being here every week.
Sorry,
every
you're asking me to
Tuesday.
stop the dissolution proceeding?
No, not necessarily, because we can't stop that. And obviously, after someone tries to kill you and then they want a divorce, then I guess that's the circumstance now.
Okay, so, and I'm trying to understand here, and I read your motion. I read the attachment. I understand, I know why you were here. I get that.
And keep in mind, I'm not an attorney myself, and I've never
I
been
understand that too.
through schooling for this court system.
Right, so what are you asking me to do today?
Well, I would like to get reimbursed for the attorney fees that I've already paid because I'm on TANF right now. And I have that here. I make $700 and something. So I do have, because Erin, when she was representing me, you know, and I had to hire her to protect myself and my children after the criminal court, you know, had already put a no contact order to protect me and my 4 children. So I had to hire her in family court to keep protecting us in family court because they're 2 separate courts. And then for her to stop her like asking for all these attorney fees and things like that, that's emotionally like.
Okay. All right, oh, well, let me hear from Ms. Baldwin, and I'll hear from your response again to that. I understand why we're here. I understand what you're asking, I think now. I did not see in your motion any request for attorney's fees. I do see, well, there is a request in there.
And
That's
then I
part of
have
number
the
7.
documentation that I have. Because that's over a $200 payment and I make $728 on TNF. So then I am left with 500 and something. And the client, he doesn't pay any child support, even though that was ordered. But I don't have an attorney to file the motion for contempt of all that. So I don't have any financial help from the father. I'm just on TANF.
Same thing.
And so if you minus out
Okay.
that $204, that's 500 and,
None of this is.
you know, to take care of the
anything.
children
Okay,
after being abused. You know, so like,
Okay, well,
whatever you want to do.
looking at the request, which is number 7 in the motion, I guess that's what we're talking about. So let me hear your response, Ms. Baldwin, and I'll hear from her again.
So again, I represent Mr. Ramos in this matter. There's no basis to award this. She presents no facts in support of her motion whatsoever. Not even attempts to submit facts in support. Any motion that we have filed has been in good faith and with a significant basis. When you look at for example, the motion to compel, there was incredible amounts of hand-holding, more so than I've probably done with any other person, to try to get them to come along and be in compliance and avoid a court hearing. And yet what we get is just obstinance. What she's asking you to do is just give me what I want and award everything in my favor and don't let him do anything on this side. That's the request. I mean, in all reality. Her idea is that anything negative that gets filed, any of her negative behaviors that get called out in court, to her, that's abusive. So anytime she violates the court order, anytime she's not in compliance with the court orders, anytime she's not answering discovery, and we bring that forth to her, well, that's abusive. How dare you present that to the court? That's what she means by, oh, this is all abusive. And again, we make extended efforts to try to say, hey, you need to comply, you need to come along, here's a letter, here's an email, here's another letter. And again, the only reason we end up in court is because after all of those extremely diligent efforts that are above and beyond,
we still can't get her to comply, and we have to get a court order for that compliance. This is a absolutely baseless motion. She goes back to the same well that, again, my client is innocent until proven guilty, and he looks forward to his day in court in this case. And so in this case and in the criminal case. So in this case, again, we're asking the court to not only deny the request, but to award fees. My client had to pay me to respond to this, and it's essentially a motion with the Appendix H slapped to it and not much more. She can't point to a single motion that was baseless, a single motion that was out of line, not a single one. And so given that it's not reasonable, I do ask for fees. I'm asking for 2 hours of my time, and it has certainly taken more than that. And that would be $1,050.
Okay, thank you. Any response to that, ma'am?
I don't even know how that would be logically possible to pay her $1,000 when I'm on TANF funds of $728. But so, and then keep in mind, I'm not an attorney, so I don't know all of the ways that we, you know, this isn't my career. This isn't my job field. So I don't know the motions and all these different things that we're supposed to be doing. I'm just trying to present to the court because it's, you know, this is for me being a domestic violence survivor, this is still abuse in the court. So yeah, I don't have an attorney that can take all of this information and bring it to you in a way that you'll understand.
Well, okay, thank you. I am probably more familiar with this case than most cases that come in front of me because I'm
Right,
dealing
been
with
with it.
lots and lots of details, and I've got mounds of information on my desk, and so this is not a case that I'm working in the dark. I am fully aware that anytime there are court proceedings, particularly when there are difficulties in getting what's often fairly straightforward information exchanged, that results in additional motions and things. Those are not that is not in and of itself abusive. When you look at what the definitions of abusive litigation are, what you're set out in the pretty clearly in what you put attached. I mean, that's an attachment. I've been through the trainings. I understand all of this stuff. Things like filing frivolous motions, filing appeals, motions for revisions, motions for reconsideration, relitigating issues that have been decided, bringing another case in another court, abusing discovery process by seeking embarrassing or irrelevant information. And I'm watching this case relatively carefully, in part because you don't have an attorney. Ms. Baldwin's a very capable attorney. I recognize this as an issue in the back of my mind that we look carefully at these. The motions that I've reviewed in this case, and there's a lot of them. If there's there haven't been any motions that I've received that I would consider to be outside of the norm that I would see in pretty much any case.
Right, because this is just litigation is a way that abuser can attempt to
Well-
reestablish and retain control over survivor,
I-
typically when forms of contact for the survivor have been restricted. And so it's designed to overwhelm the survivor's life.
But I understand that, and litigation is overwhelming to anybody who's not a lawyer or works in the system. I understand that. Litigation in and of itself is overwhelming. That is not a basis to grant the order you've requested. I mean, this is a situation that this is going to have to be processed through, and I'm watching it closely. But I'm not seeing motions that are inappropriate.
Right, that's our system. It's not designed to help any domestic survivor get out of the system. I'm aware
That
of
very
that.
well may be true.
All of these are
but-
valid. They're good. She knows what she's doing.
Well, but if, for instance, she'd filed a motion, I know we've got a motion coming with regards to taxes. We're not dealing with that today. That's in the future. If I said, this is what you're going to do on the taxes, and then the motion gets refiled on the taxes again, that becomes abusive. But if it's an issue that the parties can't resolve outside of court, that's what courts do. And it's not abusive just because a motion has been filed.
But if she's not communicating with me and working with me to come to agreements, like with the property exchange, I was just asking, and I was advised this from Northwest Justice. I was just asking that if we're exchanging property, sure, I'll give you everything that's yours. I'm just asking for the car that's mine and that's negatively affecting my credit, and that the credit union is harassing me to come and get it. And they're
Okay.
saying that I'm hiding it or like withholding it, but that's not true. And there's no way for me to prove to
None of
them that
this-
it's not
none of
true, you know?
this is
So I was
accurate.
just trying to communicate with her, but then when she refused, she said, no, we're not gonna agree on that. So then I said, okay, that's fine. Then I'll just bring you all of your things. What is it?
Okay.
What time is good for you? And that's exactly what I did.
I'm gonna object. None of this is on the record and it's
Okay,
not
if,
accurate.
if you want to file, you obviously have a right to file a motion to request relief from the court, just like they do. And I know you've mentioned the issue of the car before. It's never been part of a motion for me to address it.
It has. You've addressed it, Your Honor.
It was, it must have been a long time ago
It was
because,
some time ago. Well, I mean, long time in this case is probably, I believe this summer. So,
okay, I don't recall that specifically, but,
It's
I don't have
supposed
that
to be
minor with me.
overwhelming for us, so,
Um,
I mean,
so
but
there's a
the
temporary
truth
order.
is what happened in the
it's
criminal,
some
so
ways
we'll
back
just
in
wait
time.
and see what happens.
okay,
I'm not gonna get like my emotions all in distraught here.
okay. So what I'm going to do today is I'm going to deny the motion for abusive litigation. And that's without prejudice. If you feel in the future that there's something going on that is like a relitigation or for, the same thing over and over again, that kind of thing, I'll be happy to look at that. I'm not going to grant it based on what I have here. As far as fees on this case, I'm going to reserve. But I'm gonna give you some guidance here, okay? I can't give you legal advice. If they make a request for soccer balls and you guys, if you don't have any communication or you refuse on something where it's an appropriate request, you end up back in court, that could subject you to attorney's fees. Okay, and it's got little to do with your ability to pay, although that's one of the factors court looks at.
That's the
Um,
decision.
But I'm simply gonna say, I'm gonna reserve on that. That would be something we'll look at as far as a final resolution in your case. So, but again, you should get some legal advice, and I know that's a challenge, and I know that's a resource that's incredibly limited right now, pretty much everywhere. And I'm not in a place to do anything about that, other than say you should get some legal advice. I am familiar, I've seen a lot of the letters that have been written in this case. I've seen a lot of, and Ms. Baldwin, very competent attorney, she has probably reached out to you more than I would normally see. And I'm just telling you that from my experience. So
And I've replied to her as well.
I did submit a proposed order, Your Honor. You should have it.
I believe I do have that, and I think I can work
I think you can.
with that. I'm gonna reserve on fees. And
Yep. Spot on page 1 and the bottom of page 2.
I'm just gonna put a line through and put reserved and. With that, I will sign that order. And the most I'm gonna, if you want to step up the counter here. I might probably show you that order, what I've crossed out. And what I signed.
I just had to know, Ms. Ewald, was there anything that you needed from the court or council today?
The only thing is that I'm waiting on Nicole to get me her intake information. I don't have any of that yet. And I don't have an update from Charlotte, Rosen, or Beth, but I've reached out to Charlotte and I'll reach out to Beth.
Okay,
Okay,
very good.
very good.
So, again, I would just ask, that's the same position we were in last week with the mother not providing information, so I just
Okay.
asked that she provide.
Okay. So ma'am, I would ask you to reach out to Ms. Evald at your earliest convenience to get that information to her. All right.
Okay.
That is all, and I think we've got some other things pending in the next couple of weeks, and we'll address those unless two of you come to some agreements. Otherwise, I'll address those when they show up.
Very good, Your Honor.
Okay.
That was the last time they were in court before this courtroom stopped streaming on Zoom. But according to Odyssey, there have been many more hearings and motions since then, so I'll do my best to share those with you through screenshots. I can't guarantee that this will be 100% accurate since the entries are short and vague, but I think we get a pretty good picture of what has happened. The next hearing, which was to review the motion to compel and to discuss the 2023 taxes, was on November 5th, but it was continued. It was continued until November 12th, when the court signed an order on the 2023 taxes and took the motion to compel under advisement. 2 weeks later, on November 26th, they had another review hearing, where the court said it needed to review the filings, but it doesn't say why. Then on December 3rd, they had another review hearing, and this time, not only did the judge sign the motion to compel, but he also ordered that Mom pay Attorney Baldwin $2,000 in attorney's fees, so I think it's safe to assume that Mom was still stonewalling when it came to exchanging discovery at this point. On January 6th, a month later, we have another review hearing, this time with Judge Evans, and the following day on January 7th, they had a presentation of order hearing with Judge Basher. Although Odyssey shows that the hearing on January 7th was a presentation docket with Judge Basher, it also shows Commissioner Carmi holding Mom in contempt and ordering her to pay $130 as a sanction and another $2,500 in attorney's fees. So I'm not sure who actually held the hearing that day. 2 weeks later, there's another review hearing on January 17th, and the commissioner found that Mom was still not in compliance with discovery and ordered that she pay an additional $2,000 in attorney's fees. The next hearing, which was on January 21st, was supposed to be the final GAL review, but the hearing was continued because the final report had not been filed yet. On February 4th, they had another review hearing. This time, Commissioner Carmi ordered that the temporary restraining order should continue, and that Mom must also pay Attorney Baldwin another $1,500 in fees. 2 weeks later, on February 25th, they were back in court again, and this time the judge signed a second and third order compelling discovery and extended the temporary restraining order again. 2 weeks after that, on March 11th, they returned to court to review how the video visits have been going. This is the first mention of visitation in the records since the last time we saw them in court, but things seem to be going well enough that Dad's video visitation time is increased. On March 25th, they had another review hearing on the fourth motion to compel, and she extended the temporary restraining order again. Plus, they discussed sibling visitation. Then on April 15th, there's another review hearing for the same things. And yet another review hearing at the end of June for the sibling visitation. At the beginning of August, there were 3 compliance or review hearings in total, and at the August 8th hearing, the GAL got permission to order birth certificates for the children. My guess, and this is only speculation, is that the children needed passports for an upcoming planned trip to Mexico. With how difficult it's been to get Mom to comply with court orders, I have to wonder if the GAL was given permission to help Dad get the documentation he needs to travel. I can't think of any other reason for the GAL to need birth certificates at the same time as they're hearing a motion about international travel, although you would think that Dad could apply for them on his own. But there may be a reason I'm not thinking of why he needs help. At the beginning of September, they scheduled a special set hearing, which is what you're supposed to do if you expect your hearing will be longer than the 30 minutes that they allow for on regular dockets. They had a presentation of order hearing on September 9th, and it seems like the special set was about taking the children to Mexico. I'm not surprised that they needed extra time for that hearing. They have fought about the details of just about everything in this case, and an international trip to Mexico is not a small thing. I expect that there was lots of back and forth and a lot of concerns by Mum about the trip, plenty that I'm sure that were totally valid, but it does seem like the court has approved this travel. That was the last time they were in court. I get the impression that they may be in Mexico right now, because Dad was given permission to attend his trial setting date for the criminal case on October 6, 2025 by Zoom, because the defendant might be out of the US. And that's where we are now. They still seem to be in a bit of a holding pattern in both the family law and the criminal cases, and that isn't likely to change anytime soon when there isn't even a trial date set yet in the criminal case. They continue to keep reissuing the temporary restraining order for Mom, which is understandable. It also seems like the video call visitation with Dad and the children has been increasing. However, there's no evidence that they're doing any kind of in-person visits with the two younger ones yet. I don't think anyone thinks that the two younger ones went on the Mexico trip, but the older ones may have. It doesn't seem like discovery is complete yet, but Mom seems to have stopped completely stonewalling Attorney Baldwin after she received 4 different judgments in a 3-month period. Those judgments of attorney's fees and sanctions total up to a whopping $8,132. However, none of them show as having been paid off yet. I don't think it's a surprise to anyone considering that she's likely to still be a stay-at-home mom whose primary source of income is TANF. I feel conflicted over these judgments. On one hand, Mom's stonewalling and refusing to participate in discovery despite having been ordered to over and over again would normally deserve a sanction like that. On the other hand, if Dad truly isn't paying child support despite a court order, then his behavior is no better than hers, and arguably worse, because that money is for the direct support of his 2 young babies that he claims to love. This case left me with many conflicting emotions, and I have deep empathy for what Mom seems to have gone through, but I found her behavior to come across as combative and unnecessarily difficult for someone who keeps complaining about all the time she spends in court. On the other hand, learning that the GAL regrets her recommendation for Dad to have even supervised video calls with a therapist, his looming DV trial, and his unwillingness to pay his court-ordered child support are all things that I cannot overlook in my assessment of him, and the end result of my assessment is not good. It seems pretty undeniable that there is some level of threat here to his family from this man. How much I cannot say, but the GAL was worried, and she had access to way more info than me. The smartest thing Dad did was hire the Baldwin legal team for his cases. He has Chelsea covering the family law case, and her husband has the criminal side. I wish I could say I feel good about the side that they're on in this case, but I don't think that would be true. I don't really like Mom, but I think I dislike Dad a whole lot more. I don't know if this case will be updated, but I'll do my best with what I find. Thank you for watching.